Welcome to the 6th public hearing for the inquiry into the acquisition of land in relation to major transport projects. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today, and I pay my respects to elders past, present and emerging, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today or watching us live. Today we'll be hearing from a number of stakeholders, including local action groups, the member for Balmain, Mr Jamie Parker, Councillor Pauline Lockheed from Inner West Council, and local residents from Leichhardt and St Peters. I thank everyone for making the time to give evidence to this important inquiry today. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions taken on notice are to be provided, in this case, within 14 days. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of the audibility of the hearing today, I remind both committee members and witnesses to speak into the microphone. For those with hearing difficulties who are present in the room today, please note that the room is fitted with induction loops compatible with hearing aid systems that have telecoil receivers. And I will note that we have two members of the committee joining us remotely. We have the Honourable Shane Mallard as well as the Honourable Daniel Mulkey. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing? I now welcome our first witnesses. Firstly, could each witness please state their name and position title and then swear either the oath or the affirmation? And I will start with you, Mr Chowdhury.
Mr Chowdhury, will you be taking an oath or an affirmation today?
We take the affirmation today.
Affirmation. And yourself, Ms Evans?
Which is the longer one?
Go ahead, Mr Chowdhury.
Okay, I'm just turning this this off first before it rings on me.
Fair enough.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms Evans.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
And if I could ask both of you just to state your name and title just for Hansard as well, the capacity in which you're appearing.
My name is Ian Chowdhury for this, and I am a member of the founding member of the group.
Thank you.
Fiona Evans, also founding member of the Appin Orbital Group.
Thank you very much. So you now have the opportunity to make a short opening statement, if you like.
Thank you. I might do that on behalf of the group. I've got 14 pages to run through, but I know you guys are very pressed for time, so I'm just going to keep this to 1 minute if I can. So I just want to outline our position so you get a bit of an idea where we're coming from. So I'd like to first state that we are not opposed to the building of new housing in Appin. We're not opposed to any new infrastructure which is necessary, and we are not opposed to property developers. And of course, we're not opposed to New South Wales transport. We just don't want people hurt, both financially and psychologically. And what we hope to be able to show, today, if we can, is that people are hurting. The actual land identification process has been less than transparent, and compensation may not be sufficient to allow residents to acquire an equivalent property. We'll hand over to you for your questions.
Thank you very much. Sorry, did you say you had a 14-page?
No, I was just teasing.
Oh, right, I was going to say.
Well, these are quite serious matters, and we're nervous because we haven't been to one of these before. So just bear with us.
I was.
Break the ice.
We're going to invite you to table it.
Yeah, I was going to invite you to table it if you had such
It
a
was
thing.
so deadpan, it was awesome.
Thank you.
Well delivered.
Thank you. I will start with the opposition with Mr. Graham.
Great, thank you, Chair. Thanks for your submission that you did send in. I think, along with some other evidence we'll hear today, one of the views I think that has been put forward is really there's a bit of a difference here in the way the law works, depending on whether you're a small resident or a big property speculator. That's one of the distinctions that's being drawn here, and the law doesn't necessarily fall equally for both. Is that the sort of distinction that you're trying to draw our attention to?
Okay. Can I just quickly answer that before Fiona goes into that? The answer is absolutely correct. To our view, the most serious question this committee should be looking at is what to do so residents are not hurt. And I think this is vital to get this right this time around. So, Fiona?
Yeah, I think basically though, you've got to remember that there are people involved on the Quarry Road, as well as all other places where there's plans to put motorways and infrastructure and housing. But if there's an alternative, why hurt the people who are already living there in their own homes?
One of the things that you say is that you believe that compensation should be based on the property value prior to the infrastructure proposal being gazetted. I mean, some of the time that's actually quite important to have a gazettal date, so if there's an uplift, that the public can capture that uplift. It's not just automatically going to private interests. Well, that's true for some development, but in your case, if you've got a motorway, a freight rail corridor coming nearby, it might actually be decreasing the value of some of these properties, and that's where your view would really come into place. That's actually the situation you're trying to grapple with in your area, though.
Yes, absolutely correct. But we're not just talking about our area.
Yeah.
We're talking about the whole of New South Wales.
Yeah.
Because I think this committee has got the chance of getting this right. Unfortunately, it hasn't been addressed before, and maybe this is the time to be addressed. And the answer is that what we are really pushing forward is no different from what the Commonwealth Act is in regard to acquisition law, no different from what other countries, like I've lived in Canada, I've used that as an example, and that is people are just simply reinstated to a position so they can buy the equivalent property. And I think if you did a pub test on that, I would say most people in the pub would say that's fair. Whereas now it's based on a market value, which really is an artificial value, because you're asking people, which are very certified values, to basically do an artificial value of the property. Why don't you just simply arrange it so that people are compensated at such a level they can buy the equivalent property?
Yeah.
That's a very fair system, and that is what is in most jurisdictions in Australia as well.
Yeah, but so accepting that, and you put that in your submission, how do you feel though about unhinging this decision from the moment of gazettal? That risks in other places where properties are going up that this benefit, this value, will be captured by private individuals, not have the opportunity to be captured in the public interest. If we moved away from that moment, which is often the moment where information then becomes public, often the agencies keep things quite private till up until that point or close to that point.
Okay, now I see what come out.
You can do it.
Okay, you're absolutely right. When this is gazetted, and let's assume it is gazetted, and just say that the option is not the blue option, the yellow option, which is where we live, by the way, our values will go down because nobody's going to go and buy a property there, not knowing what is going to happen by 2040.
Yeah.
But if buyers knew that that property in 2040 is going to be valued based on the reinstatement value of that property at the time, we would not be held ransom in our own properties for the next 20 years. We'll be able to sell by telling the new buyer, the law is the law in New South Wales, which will have to, of course, be changed, which allows the person who has got that resident to at least be reinstated.
Yep.
And that would be wonderful for us, because then we're not stuck
Yeah.
where we are until 2040 or whatever year it is
Yeah.
it happens in.
And
Is that what you meant?
Yeah, no, I think
Yes,
that's a
exactly.
really good point. And if the one of the discussions in the transport agencies are, well, let's do corridor planning earlier. That's good for everyone. A little bit more certainty. It means the state makes sure that the transport corridors are preserved. If that's the direction they head, then your point is even more important, isn't it? Because it deals with the
Absolutely.
significant uncertainty that residents in
The
those corridors
consequences,
might face.
And also to bear in mind, it's not just the residents buying a new home or being able to move, but you've got to bear in mind that the residents in this area run businesses from some of these properties, and they rely heavily on overdraft facilities from their banks. Can you imagine what a lender is going to do? Is going to sit back and say, wait a sec, this property may be subject to acquisition, has been considered that way, and it's going to be based on market value. The bank's going to sit back and say, that equity amount you think you've got is going to come down. The second one is if somebody needs to sell the house getting close to retirement. Under superannuation law, they're allowed to contribute up to $300,000 each into super without being taxed. But they have to sell the property fairly. And the third one, which is one of our groups came up, which is a very good point, is that they have thrown all their money into these properties, into their property, so there's an inheritance for their children. So these are three factors that are affected if the value at acquisition date is not a reinstatement value, as per the Commonwealth Act.
Yeah, no, thank you.
I can also just add, sorry, if you don't mind,
Go for it.
when Russell did the review in 2014, which the New South Wales Parliament released in 2016, recommendation 17 was for reinstatement. But conveniently, the minister at that time, when went to the House for the second reading for the bill to be changed, conveniently forgot to mention this and referred to the Pratt review only. The Pratt review, I don't think, was very transparent. So the bottom line was, I don't think most people in that parliament realise that market value is really an artificial value. And this is why we're having problems today in different areas of New South Wales because of that compulsory acquisition. People are saying, I can't move to the same property I've got now. So I think it's very important that Parliament notices that and have a look at the second reading by the Minister at the time, who says that 80% of the people were very happy to agree with the department. The department is not evil. The department's a good department, I'm sure. But they have to work within the law. And the law states the agreed value. And the agreed value is an artificial value based on a certified value of getting there and trying to work out, okay, what was the impact? Let's just get rid of that. It is simply reinstatement. Put these people back in another property somewhere close by.
Thank you.
Very straightforward.
I think it's coming out quite clearly from your evidence.
I'm not being too harsh, am I? I don't want to.
No, you're not being harsh enough, I think.
Oh.
When we look at the Just Terms Act and we look at the objects, the first one is around that market value point, and then the second one is this kind of nebulous just terms for acquisition. I think you said before, what would the average person expect to happen? And I think you nailed it when you said they would expect them to be, a person to be made whole if they were to have their property
Yes.
acquired. Do you think there should be a different approach though for small business owners and people who are losing their homes versus property developers and large businesses?
Fiona, do you want to answer this? Oh, okay, sorry.
You can have that one.
We meant to share, by the way.
Yes,
but,
you are.
but Fiona-
I'm the emotional
Quiet.
side. I'm the one who wants to stay
Well,
in
you
my
had an
house.
indication, but I go like that, cry.
Yeah.
In all seriousness, ask your question is that we think everybody should be done fairly. So we're not opposed to property developers benefit from the uplift. What we're opposed to is that they benefit for the whole lot. So what we're recommending, as you saw in the submission, that there's some sort of capital gains levy attached to them so that some of that uplift goes back to the New South Wales government, allowed to pay compensation to the residential people affected and also to the state. I read somewhere that 600 or 900 million dollars has been lost by this government by not having a capital gains tax levy or capital gains levy on major property developers who have got huge land banks. So the distinction I'll make is between the ones holding huge land banks against business owners and residents. Does that sort of answer your question, Madam
It does,
Chair?
thank you. Mrs. Evans, can you tell us about your experience then? Because I think one of the the Act is quite clinical in a lot of ways, and what we've heard from other people is that the way it's been implemented can at times be quite harsh and clinical. Can you tell us about sort of the impact?
Yeah,
that it's
well,
having?
initially, I mean, the first letter that we got that was dated the 16th of November, so obviously didn't arrive with residents at their homes until after that date, with a deadline of the 14th of December to come up with submissions was, we considered, grossly unfair. Not enough time to put together a whole story about why you would want to stay in your home, because there's just too much emotion involved, turmoil, angst. A little bit more time would have been a good start. We also, various residents had got wind of information before the letters arrived, which put a big question over what was going on initially. We did get an extension until the 29th of January, but then it took until the 1st of September to even get a preferred option, which was a long wait, and we're still obviously hanging. We still don't have a definite answer. And I think one of the things that upset most of the residents was how much consideration was given to the actual homeowners. And I think Honourable Mark Benaziac, I think in one of your hearings, you did quote, the yellow line goes straight through farmland. It doesn't. That's where our homes are. So that really says it all. How much was given to the homes and the people, the lives that are affected on that yellow option. There was lots of studies done for lots of other reasons, but there was very little mention of the people who actually lived right under that yellow option.
So the impact on people is kind of devalued in that decision making
completely.
process. Sorry, over to you.
Yeah, sure. Can I just pick up on that point in that questioning of the department? They said they were reconsidering the yellow and blue line options. Have they come back to you to talk to you about that reconsideration?
No.
No. Okay. Because obviously, I think from the evidence we've seen that the yellow and blue line option is they're putting a lot of heavy weight on the environmental impacts rather than obviously the human impacts of their two options. So that's concerning. Probably one question I'm going to ask all witnesses today is that during this hearing, the Valuer General gave evidence to say that the valuers, he found them to be not following legislation, regulation or policy, and he was concerned of incorrect valuations. Would you like to see a recommendation coming out of this inquiry that we request that the Valuer General do a proper audit of valuations done previously so we can, I guess, get a sense of how out of whack the valuations have been on some of these acquisitions?
Mark, we haven't heard that before, but that is an absolutely outstanding comment you just made. Yes, we will actually support the concept of looking backwards at how the valuations were determined and were they actually fair for those people who have been adversely impacted.
Thank you. That's it for me.
Over to the government. Go ahead, Mr. Fang.
Thank you, Chair. And look, thank you very much for coming in today. I'm going to pick up on some of the themes that the Honourable John Graham raised, and he's spoken about how when you have an acquisition or the government having an impact on land, there is that issue around the valuation either going up or down, depending on, I guess, the project that is slotted for the impact on your land. We've discussed a number of ways to perhaps address the valuation issues that you've raised. I was curious as to, in your circumstances, how you would propose not only the way that you've sought to have it addressed, i.e. a like-for-like issue, but is there any other ways that you would see it as being feasible to address that valuation? And the reason I ask that is because there will be perhaps people who, instead of having a house that's purchased for them that's similar, they may wish to actually perhaps downsize if they're older, or perhaps relocate altogether, maybe even overseas. So while I understand your proposal is a reasonable one in perhaps the circumstances you're both in, it may not be suitable for everybody who is affected. So I was just curious if you've made some or given some thought to that.
Do you want me to do that?
I'll go first.
You go forward.
Chip in.
Okay.
Well, I think, but regardless really of whether you're going to downsize, it's the financial value of the property that you've invested in for your future. So the equivalent financial value would be the same.
I
That's what you're
understand
taking
that,
forward.
but that almost seems in conflict to the answer you gave originally, which was you're asking people to give you a valuation and it's artificial, and I think that's where I'm trying to process what you've actually said, is that you want a like-for-like scheme, and I understand that. However, for the people that don't wish to actually have a like-for-like, they may perhaps wish to, say, for want of a better word, cash out. That, there has to be that ability to have that valuation, and obviously John Graham has indicated that there perhaps are a number of ways to do that. I'm wondering if you've given some thought about that, and what you would see as the most equitable solution in that circumstance.
The group has looked at that, whereas I should have raised this earlier, so thank you for raising that point. The answer is Section 56 of the Act, Clause 1A. It talks about increase or decrease, and there can be cases where there's a decrease, because can you imagine what happened to everybody in Appin if a nuclear depot was built there? Everything's going to collapse. So what we say in that clause is remove the word increase. So all the Parliament has to do is remove one word, basically, from the Act, and we've solved the problem. So to answer your question, if it decreases because of the incinerator being built there, well, that's a bit unfair. But if it increases, we should be compensated for it. So are you saying, are we having a bet each way? And the answer is yes, we are. But more people are hurt because of the uplift, so they can't buy a like-for-like, than the other way around.
So can I just clarify then on that point? Are you saying, so I understood from your opening remarks.
It was 14 pages, by the way, so I just cut down.
That really it's about providing a like-for-like. So if you were to be effectively kicked out of your home without you having planned that and it not being your fault, and we're all accepting that these projects need to happen, and another home can be found in an area that is effectively of a similar nature, as close to schools or whatever it is that you require. If that amount was lower, or the amount to basically relocate you was a lesser amount than the value of your property, would the result then be that you would, I guess, be looking for that additional amount based on market value, or based on, would it be acceptable then for that to be based on, so I guess, the 2 years, that additional amount of compensation be based on the I guess the market value 2 years before?
The market value, again, is a concept which is misleading. It's really an artificial value. So let's just get the facts right here. It's an artificial value because during this period, the values are going to drop because of uncertainty. So let's not go there. If we're talking about perhaps residents getting enough compensation to buy a property somewhere else, that's not what we're asking for. We're asking like for like, which means if they live in Appin, they should be compensated enough so they can buy another equivalent property in Appin. That's what we're talking about. Not out middle Burke or something, Appin, the same area. Now, if that compensation they get is lower than what it costs to go and buy a place in Burke, so be it. That's the market.
Yeah.
They should be able to at least buy like for like.
And I'm with you there, and I agree.
Oh, sorry.
But
Okay.
for in the circumstances where you can get like for like, and it doesn't actually cost as much as what you would be entitled to if there was to be a market value compensation, are you saying that amount should be? What am I asking? I guess I'm asking, what should that additional amount be based on? Should it be based on the amount as if the project had never been announced, or should it be based on the amount that the property would be worth with an uplift because the project had been announced?
Okay.
Yeah.
Answer in two parts. Very first part, if the infrastructure is going to cause a down price, well, we're not very happy with that, of course. If the infrastructure is going to cause an uplift, we would like to receive that. And that, I think, is fair. So to answer your question, if somebody's going to build the nuclear depot on our street, well, the whole lot's going to come down. And if we're just going to stick with one concept, it's like for like, so be it. Because not everybody's going to win out of this.
What if it goes the other way?
Either way, we just have to wear it.
Sorry, Wes, I've taken your your questioning, but
It's your birthday.
No.
That's my gift to you.
thank you.
Well, do we get a birthday cake?
It's very cheap.
I'm a cheap guy.
Okay. So my question then is, I understand what you're saying if if there was a nuclear facility to be built there and the values actually go down. But in the case where the values go up around that particular project, but at the moment you would be offered a market value based on before the project was announced. If instead we were to look at more of a kind of a like for like, would you be arguing that if you were to still be able to live in Appin and have basically a like for like, but it turned out to be cheaper than the amount based on the market value, would you be arguing for an excess amount, or not excess, but for the compensation to include the difference between the like for like and the market value 2 years before, or the market value with the uplift?
Okay, now, so I didn't quite understand the question before. Now I understand where
I
you're
don't
coming
think
from.
I said it very well the first time.
I'm sure you did. It's just I'm a bit nervous, so I didn't quite click to it. The answer to yours would be that the uplift we would expect to go to the residents. But if there's no uplift, for example, I don't know why there would not be an uplift, well then they shouldn't be paid extra market compensation.
Understood.
You can't have everything both ways, because we as taxpayers have to pay for this in the end, and I think that'll be unfair to reward somebody who normally will be taking that risk, by the way. If you buy a property, all your properties, you take the risk that sometime in the future it may be worth less than what you paid for.
Yep.
But everybody else around you will also get less. See what I'm getting at?
Yep.
That's what I think is fair.
Thank you. That's
Does that answer it?
that did answer
Yeah.
the question. Thank you very much. Unfortunately, we are out of time.
Use my time.
It was a gift. Thank you very much for attending. We may have some supplementary questions for you, and if that's the case, you'll have 14 days to respond, but the Committee Secretariat will be in touch if that does occur. So thank you very much for coming. We will...
Can I make a closing remark, please?
Please.
Because we did start a bit later. And I did cut our
go.
mind down to 1 minute. Okay?
You did,
Okay.
instead of the 14 pages. Go
What
ahead.
we want to say, and this is very seriously, is that we want to thank you all for being in this committee. We think the job you've got is very, very difficult. We greatly appreciate this. We greatly appreciate the government has been brave enough to even open this up. Sorry, this is a can of worms, and I think this is a very difficult question. You folks have got one chance of getting it right in our lifetime. Please don't let it be wasted. Thank you.
Message received. Thank you. I'll now welcome our next witness. Thank you very much for joining us.
Thank you.
Ms O'Brien, if I could ask you to state your name and position title, the capacity in which you're coming today, and then swear either the oath or the affirmation.
Certainly. My name is Ms Jo O'Brien, and I am here on my own accord today, but I am an active member of the Outer Sydney Orbital MacArthur Action Group, and I will take an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And would you like to make a short opening
Yes, I
statement?
just have a one-page statement. Thank you.
Go for it.
Thank you for inviting me to speak today and for including the Outer Sydney Orbital in this inquiry. I am not speaking here as a representative of any group, although I've been actively involved with the Outer Sydney Orbital MacArthur Action Group for over 4 years. The announcement and intended path of the OSO in March 2018 was a complete shock to most locals. Staff from Transport were sent to knock on doors, drop off an envelope, and they were not keen to stay and discuss what was happening. Hundreds of people were confronted with the unexpected future acquisition of their homes and given only a few weeks to assess this large-scale project and make a submission. It is unacceptable to leave people confused and distressed like that, especially without any prior warning that an acquisition was even a remote possibility. No neighbours to the corridor were notified at all. There was no expectation of development in this metropolitan rural area. Such a large motorway, 8 lanes, 2 freight rail lines, would completely change the area and impact us all. Consultations should have begun at the earliest stage with everyone who could potentially be impacted. We should have all been directly notified of the 2015 consultation, which was unclear and poorly advertised. In 2015, the process of determining the route of the OSO was outlined, consisting of a number of steps, including a long list and a short list of options for public consultation. This never occurred, with only one final option presented in 2018, an option which did not even appear feasible from an engineering viewpoint. There were also meant to be further community consultations which have not occurred. There must be full consideration that this is more than a planning exercise, that this seriously impacts people's lives. These are our homes, our livelihoods, our communities, as well as our biggest financial asset. There must be time and assistance for people to understand and assess the proposal and all relevant documents. Locals read and researched and shared information to help each other try and make sense of what was happening. As we researched, we realised there were big plans for Western Sydney that locals had been unaware of. However, these plans, including the OSO, had been widely discussed at various industry organisation meetings where developers, major landholders and lobby organisations were briefed by government officials and ministers. After a huge public response, in June 2018 a long tunnel was announced from Cobbitty to Cawdor, despite long tunnelling required being said to be a fatal flaw of any corridor option. Since then, there has been no public communication on the OSO. Landowners were advised they were no longer under the threat of acquisition, but no correspondence was sent to many of those who made submissions. There have been no answers to the questions and concerns of the community. There is no report of any type on either the 2015 or 2018 consultations, and the submissions have not been made public. The community is still in limbo, the process unresolved, the threatened gazettal and acquisition has not occurred. There have been no further public consultations. It has been 4 years. The community does not believe this is over, and the shadow of the OSO is not forgotten. It is impossible for those affected to heal. Trust has been destroyed, and rumours of alternate OSO paths persist. There have been life-changing long-term impacts. It has changed our community, and there has been no support. I am here today to share my experiences, my observations and my research, with the hope that such a process will never happen again, and that our community may finally get some answers. Thank you.
Thank you very much. Is it possible to table that document for the benefit of Hansard?
Yes, for sure.
That would be great. Can I just clarify with you before I pass to the opposition? So 4 years
4 years.
of not knowing what's going to happen
That's right.
with these properties.
That's right. While the tunnel removed hundreds of properties from the corridor, there are still properties within the MacArthur area in Menangle and Cawdor and Cobbitty that are still in the path, and also all the properties that are north of there as well. So I've only looked at the Macarthur region particularly, but all those other ones, as far as I know, have not been gazetted either.
Thank you. Mr. Graham.
Great, thank you. I wanted to thank you for your submission. I really found it excellent and
Thank
really
you.
helpful. These are obviously really important projects, but you've really spelt out the impact they have on local residents as they're coming to terms with this. And I think the point you were making about the fact that while the law might be equal, it falls differently on different people, I think really comes through here. It's different if you're living your life, trying to work, manage at home, compared to a property developer who might be studying carefully all the documents that come out.
Yeah, I think that's the thing. Not so much that the law is different, but the consultation process falls differently. So if you've got an interest in these things and you're looking out for all of these public consultation periods, and a lot of larger landholders and organisations were directly consulted, smaller landholders didn't get that opportunity at all. The 2015 consultation, I'm a fairly aware person, watch the news, read newspapers. I had no idea that occurred. As did many other people.
And to put, the thing that the agencies would say to defend themselves is, look, the law is equal and all this was made public, but really your point is that's not how it works in practice for ordinary people living their lives.
It isn't. Since then, I spend a lot of time looking at public consultations, and I actively write submissions for things, and I also try to help other people understand what's going on. So raise awareness through Facebook groups and things, so that people know that this is the first round of this consultation. You can comment now and make a difference. Whereas by the time people found out about this, it was one option, not multiple options, just one option. And people weren't really led to believe they could alter that in any way.
Sure. And you're now watching this closely. Some of this isn't public. So those 2015 consultations, 2018 consultations.
No, I look quite regularly, and there's no report. The people that were just here on the OSR too, because I also put in a submission on that, they had that resolved within a year. So that whole process has come and gone, and there is still no report. There is no gazettal. We've been told there might be a gazettal, end of 2018, 2019, and it never happened.
And when you, and you refer in your submission to the concept, to gazettal, a concept that was promised long before now.
Yeah.
Can you just tell us, in the community's mind, when was that promise made? Who made the promise? Where did that idea
that was
start?
Promised from, I'd say, transport, local state MPs, that we would have gazettal by the end of 2018. A few of us went to see our local member and sent some questions through that went to transport and came back again. And I think then it was meant to be the end of 2019 or possibly the beginning of 2020. And it's now 2022.
Yeah, so in the community's mind, you were told this would happen, you were given some dates.
Yeah.
But you've just heard nothing.
Nothing. There's just no response, and I know that various people have contacted transport and they get a non-committal response. If you ask where the reports are, they say, well, that'll all be made public when there's a gazettal. When will the gazettal be? When it's finished. Yeah.
And have you been given any credible explanation for the delay?
No.
Yep. I might conclude there. Chair, thank you.
Thanks.
I wanted to just talk a bit more about that delay and the limbo. And we've heard in this inquiry already from businesses who have been subject to, this kind of threat of acquisition and not knowing what they're going to do for year on year. I know we've heard a lot about trying to keep things equal between sort of big developers and big business and everyone else. But it strikes me that the impact on a homeowner when you're in that sort of limbo is actually a very different thing. Would you agree with that? And can you talk us through, I guess, the real life impacts of not knowing when your home's going to be acquired or if it will be?
I can give you a second-hand experience because I was not under threat of acquisition. So I wasn't in that position. I just had that opportunity to observe everyone else. I think it means you can't enjoy your property, that you're reluctant to do anything to improve it. This threat of acquisition, it's hard to know whether it's this year, next year, or decades away. So you have no idea how you can sort of enjoy your home, I think. And whether the value might suddenly plummet because it's under threat of acquisition. What I've noticed is that properties have sold. So properties that were in key locations in the former corridor before the tunnel have sold. So people that were living there, in this area, people live in these places for decades. They're long, people in the Camden area in particular, quite often stay in Camden for generations. So they're multiple houses on the same property. And these properties are being sold and people are moving on because they are worried about what the future holds and they've just got no clue what it might be and when it might be.
Are they selling, so they, even though they've got this kind of acquisition notice hanging over their heads, they're still able to sell the
I
properties?
think I'm talking more of the properties that were once in the corridor.
Yeah, right.
Because people don't believe in the tunnel, to be honest. So they think it's going to come back.
I can imagine also that, things like decisions on which schools which high school you might send your child to, or things like that are going to be up in the air if you don't know if you're going to be living in the area.
I think everything's up in the air. And it affects such a large area. It affects a lot of, circling around Camden like that. It affects a lot of people in the whole area. So it's not just a case of if, your house is under acquisition here, you can go over there because this whole area will change. I think we all live there because it's a semi-rural area and it's on the outskirts of the city. And no one expected any of this development. When this was announced that we'd never heard of an aerotropolis or a city around an airport, none of that seemed to be in the future. So everything's really changed in these 4 years in the area.
Do you think when we talk about making people whole and making sure that they're able to live in a kind of like for like property as being their ideal sort of objective of the act, do you think that people should also be sort of compensated or made whole for the emotional distress and inconvenience, etc., of the acquisition in a way that takes into account how long they've been under the acquisition process?
Yes, I think there should be compensation for the delay here because it's just been limbo for this many years. And you can't, you wouldn't, the ones that are still in the corridor, I imagine, would be very difficult to sell in any way. But then they may not get compensation for 20 years. So that's a long time to be on hold.
Yeah, absolutely. Mr. Benassia?
Sure. Just picking up on that. How do you think we would be able to quantify, I guess, that mental anguish? Like appreciating the mental anguish. I'm just also in the back of my mind going, well, how does one even quantify that?
I'm not sure I'm qualified to even have a guess.
How do you put a figure on?
How
do you put a figure on that? I think it's a fairly difficult thing to do.
I think it's a difficult thing to put a figure on, and I don't think I'm qualified to have even a guess at that, particularly not having been through the process.
Yeah, sure. Do you think, just on that, do you think enough is done by the various government departments to look after that mental health impact? Do you think that more support needs to be offered at the point of someone knocking on your door saying, we're taking your home, you're taking your property?
That's right.
There should be more offer of that emotional support as well as, this offer of financial compensation.
I think so. I think from the point of view of a lot of these residents, they had absolutely no expectation that anything like this could happen. If we'd have heard about an outer Sydney orbital or a road from the airport, we all assumed it would go north of Camden, following much the path of the Northern Road and Spring Farm Parkway around that area, where the rail line was. So in the consultation in 2015, a lot of the publicity was about the passenger rail line, which was going through homes. And so the idea of an outer in the orbital was just not there. So there was absolutely no expectation. And then one morning, and I think they were often junior officials from Transport, came knocking on a door, handed over an envelope, and from what I hear, often didn't stop and explain it all. And just said, oh, it's in the envelope. And then it says, your home will be acquired. It doesn't say, would you like to participate further in this process? So I think it's sort of that and they just walk off, and then people are left in quite a lot of distress with no support. We supported each other. And I think that's why I've continued to remain involved, to try and help other people, because it just seems so unfair to do that.
And just picking up from the previous witness, where they sort of explained like for like isn't necessarily the same house, but in Burke or Broken Hill, but it's like for like in the same area. Given the nature of Camden and it's semi-rural, and that's what a lot of people move out there for.
Yeah.
But given the nature of how it's all changing, do you think that like for like is even achievable, given the
it possibly
unpredictability
isn't.
of what's going to happen in that area?
It possibly isn't. Some of these properties are several acres. They're not sort of small suburban properties where you could buy another house at the same size.
Yeah.
And if it's a family property that's been in your family for over 100 years, this is quite a big deal to leave it. I don't know that you could quite get like for like. And I don't quite know how you solve that, no.
Yeah, sure. And just my last question, and I'm going to be asking all witnesses this. The Valuer General admitted in a previous hearing that the valuers weren't following legislation, regulation or policy in terms of doing the valuations. Mm-hmm. Would you like to see a recommendation out of this inquiry that we request that the Valuer General go back and look at, or have a deeper look at past valuations to get a sense of the extent to which valuers have got this wrong?
Possibly, but again, don't feel I'm qualified to answer that one.
Before I hand over to the government, just one more question. The process, and when we're looking at this kind of, I guess, the emotional wear and tear on people through this process, which we've heard a lot about from a lot of different communities, there are, in most of the areas that we've looked at, there have been sort of groups that have come together of like-minded, sort of equally affected people, and good people like yourself who are sort of neighbours and helping. Do you think that there is perhaps scope for the Act to be changed to allow more of a group of residents to deal with the acquisition with Transport or whoever the acquiring agency is, instead of being sort of only dealt with as individuals? Would it help if there was transparency over the entire acquisition process?
Yes, I'd agree with that. I think Transport were speaking individually to people, and apparently still are speaking individually to landholders on a private basis, but that means that people don't know what's going on between each other. And I think the greatest strength of our group, we don't have a formal structure or anything, we just came together as individuals to provide the support that was not given elsewhere, I guess. So perhaps if the acquiring agency was to provide some sort of support for the coming together of that sort of group, and perhaps to even encourage it, and then to provide that transparency over the acquisitions as a whole, rather than it being a individual versus I think
the agency.
transparency is definitely a key for sure.
Thank you. Mr. Fang.
Thank you. Thank you for coming in today.
Thank
I've
you.
only got one short question. So I just wanted to ask, obviously we've spoken a bit today about the emotional toll that an early announcement around corridors and the like creates for the landowners, the residents, etc. But I wonder, is it a worse outcome if it was to be, I guess, sprung on people that their properties are being acquired without that ability to process, consult, etc., that an early announcement provides. There's always that flip side with these issues, and I'm just curious as to how you think there's a better way to do it, given that there's often complaint about the way that it's done when it's announced and you know, it's quickly sprung on people.
Yeah.
But at the same time, obviously, as you've said, that long tail of announcement, consultation, resolution does create anxiety for people. How do we best manage that, do you think?
I think there's no easy answer. If you're going to take someone's property, that's always going to be difficult. But I actually think that this long saga is actually harder to deal with because you're sort of left in limbo for a long time, so you can't emotionally move on. That especially when it's your home, you're in that limbo for a long time. This process in particular, I can understand why it was done, why they wanted to reserve a corridor before the development overtook that area, but in some ways they kind of missed that a little bit anyway, certainly with the rail line. But I think leaving people in limbo for 2 decades is quite ridiculous, and certainly 4 years without any certainty at all, not even gazettal, no opportunity to be sort of acquired and to move on at all. I think it's just it's a difficult process for everyone to go through, and I think perhaps one of the answers to that is better consultation up front. So at that very early stages, the 2015 consultation, everybody that was in that great big wide purple swoosh should have got a letter to say this was a possibility, and then you have that chance to input. And I think if you at least you had a chance to have a say and have an input and make a difference to whether your property was in that line or not, you could feel that some satisfaction in that. But this was actually sprung on people as a complete shock.
Thank you.
Thanks.
Under the legislation, there's a 6-month period of time from gazettal to having negotiations before the property is acquired, and then there's a provision in there that the property then should be acquired as soon as possible. But prior to gazettal, there's no real sort of time period. No. Do you think perhaps that these acquiring agencies are sort of hedging their bets a bit by saying we probably want this land, but we don't know when we want it, so we can't buy it yet. We're just going to kind of let you know and hold on to it. Do you think there should be basically a put up or shut up period of time where you've done your consultation, you've worked out which route you're going to use, and then they should just be obliged to buy that land?
Yes, really. I know it's a bit different in a corridor to in a lot of the other land acquisitions where they're closer to knowing the exact path. And I know there are still a lot of refinements to do on the path, I guess subtle refinements, but you can't leave people in limbo like that.
It's about who bears the risk, I guess.
Yeah, so and people could be, I don't know how the legislation works exactly, whether buyers of properties are being notified that this is a possibility. And then there's even things to do, like anywhere that's underneath or above this tunnel is not being gazetted. So people in the future could end up with an exhaust stack right next to them, and the implications of having a tunnel under their home and have no idea. So if the government agency was to say, look, we're probably going to take this, we're not sure what kind of in what form yet, but we're going to take the risk. We're going to put these property owners out of limbo and allow them to get on with their lives. Yeah. If we then decide further down the track we're not going to use this land, well, we can sell it then. But at least then it's the acquiring agency taking the risk rather than the burden being on the landholder. Yeah, I think that would be fairer. There's a possibility of the value going up, like they were saying before, but I think that, it's that being in limbo when it's your home. It's not an investment portfolio, it's your home. Yeah.
Thank you. Did you have another question, Mr. Fang?
There we go, boy. Put up or shut up.
Put up or shut up.
I like it.
Very good. Did anyone else have any questions? No, I think that brings us to an end. Thank you so much.
Thank you.
For your submission. It was very good, very detailed, and for your evidence today.
Great. Thank you very much.
Thank you. We're going to take a short break. We'll be back at 11:15. Excellent. So I now welcome our next witnesses. Mr. Parker, you have already sworn an oath as or affirmation, as part of your role as an MP, so you don't need to be re-sworn. But Councillor Lockheed, if I could ask you to state your name and position title, and then swear either the oath or the affirmation.
Thank you. I'm Councillor Pauline Lockheed from the Inner West Council, though I won't be speaking on behalf of the Council today. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mr. Parker, would you like to begin with a short opening statement?
Just before
Yes.
Mr. Parker does, I'm having confirmed because during the bus privatisation inquiry, we had to get the MPs there to actually swear in. So I don't
I'm
believe.
happy to do it. I'll do it.
I'm just. It's just for the.
Understood. Why don't we just do it just in case?
So my name's Mr. Jamie Thomas Parker. I'm the member for the seat of Balmain. I'm appearing here in my role as a member for Balmain, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And
Thank
now
you.
if you'd like to give an opening statement.
Well, thank you very much to the committee for this opportunity to speak to this inquiry. I've been the member for Balmain for close to 12 years, and before that I was a councillor and mayor of Leichhardt Council for 12 years. So I've dealt with scores of residents and also the council that's faced public acquisition and significant hardship. In my electorate, the major transport projects underway include West Connects, the Roseville Interchange, the Western Harbour Tunnel and the Sydney Metro West. Obviously there's a need for compulsory acquisition when it comes to progressing major transport projects, and I do of course acknowledge that there has been improvement. I worked on that under the former Premier Baird as a result of Mr. Russell's review. I'm here to be very constructive and to make 6 key recommendations. 1, that we reform the process around negotiations with landholders. 2, that non-disclosure agreements should not be imposed. 3, we should reform the basis on which compensation is calculated as per the reinstatement recommendation 17 from the Russell Review. 4, we need to review the hardship application process. These are people whose homes most often have been damaged or have been made basically unlivable, and they have to beg transport to buy their property from them. 5, to pay fair compensation for substratum acquisition, a form of acquisition that actually does have impacts on the market value of a property. And 6, reform disposed owner rules. So these are people that have had their properties that have been dispossessed. Reform those rules and return surplus land to the community. I look forward to taking questions on those matters. Thank you.
Thank you. And Councillor Lockheed, do you have a short opening statement?
I do. I thank the committee for inviting me to give evidence today and for holding this much needed inquiry. It has now been almost 5 years since my family finalised our compulsory acquisition, and I still find it very hard to relive what we went through. It really was that traumatic, and I know the committee has heard from many others who also found the process to be brutal. It should go without saying that a government should not treat its citizens that way. I believe many of the issues with the current system lie in the huge imbalance in negotiating power that exists between the person whose property is being acquired and the government agency acquiring it. The impact of this can be seen in the consistent and extreme lowballing of offers made to people whose properties are being acquired for transport projects. This happened to my family and many others in my community, and there is an urgent need for further legislative reform to level this playing field so that people whose properties are being acquired are treated fairly and compassionately. Introducing a truly independent mediation service with the power to make acquiring agencies genuinely negotiate early in the process would help, as would providing people with the upfront funding they need to access legal advice and support. Residents should also be offered reinstatement value, so they receive enough compensation to buy a similar property in their community. As well as legislative reforms, there is also a need for deep cultural change in the way the New South Wales Government and its associated agencies approach compulsory acquisitions. Back in 2016, when the last reforms to the Just Terms Act were introduced, I was a spokesperson for the WestConnex Action Group. I said back then that there didn't seem to be anything in the reforms to stop government agencies from making people fight for their entitlements, and that unless that culture changed, the reforms would be meaningless. It's clear from the evidence given to this inquiry by people who've gone through the acquisition process since then that this is still an enormous issue. People are still having to fight for their entitlements and suffering significant financial and emotional trauma as a result. I encourage the committee to look at how the government can reform the culture that allows this to happen, as well as the laws that enable it. I've also noted my concerns with the way properties were inquired for the WestConnex project well before planning approvals were granted, as well as Mr Parker has noted, the lack of compensation for substratum acquisitions, and I would be happy to answer any questions the committee may have on those topics as well.
Thank you very much. To the extent that you have your opening statements in a form that you could table, it would be really useful for Hansard. Thank you. I'll start with the opposition. Mr Graham.
Great. Thank you, Chair. And thank you for both your submissions. I want to acknowledge the fact that you're both living in areas which have been heavily impacted by transport projects. I mean, you've got a disproportionate amount of experience in this area. I might first ask Mr Parker about one of the those signature acquisitions which clearly went badly wrong, and just any of the lessons that have been learnt out of that, and that is the Balmain Tigers incident. The committee took evidence, it's been quite public. What are the lessons out of that experience that you'd like to put in front of the committee?
Well, we've seen a similar situation to that in Darley Road in Leichhardt, where the EIS is developed for a project and there's an indicative tunnel route which is determined. And that indicative tunnel route will then lead to decisions about dive sites. So that's where they actually build the acoustic shed, and the trucks, the header machine goes in the ground and the trucks take the spoil out, a dive site. And what happens is that the EIS is done and the transport says, well, we think this is what the route will be. But of course, the contractor is the one that determines the route. The contractor will come in after a very long, prolonged, bidding process and the tender process, and then we'll say, well, actually, we don't need that because we're going to use this type of way forward. What that means is that transport can sit on a property for months and months and years. And what that means for someone like Heworth, and I have no relationship with Heworth apart from them just being a developer in the community, is that they can't get finance, they can't move forward. It just means that they have these huge holding costs and opens up the state for significant compensation claims. It's completely unsatisfactory, and there needs to be a process where, at least when it comes to the route and how the dive sites are determined, happens earlier on in the process, so that people aren't dragged out for a long time. But it also reflects, as Councillor Lockheed said, the psychology of transport, which is everyone else comes second and we're first. And we see that in so many instances, and that has to change.
And do you think there is potentially an issue with significant compensation given what's happened in that side?
Yeah, I think there's no doubt that Heworth has had significant pecuniary losses. We talk a lot about non-pecuniary losses for residents, but significant pecuniary losses, holding costs, unable to get finance, lost income. My strong suspicion is that there'll be a very proactive campaign by Heworth to seek compensation. And you can understand why that would happen.
And then I'm interested in your view on the culture of some of the agencies over time. What we've had some evidence about, there's the law, but there's also the culture that the agencies approach these land acquisitions with. One view that's been put to the committee was that while there was clearly significant issues with some of the RMS acquisitions related to WestConnex, that improved a bit over time, and that the culture in Sydney Metro at the moment in some ways is more of a problem than what had become of the RMS culture. So I'm not sure, given your experience, whether you're in a position to comment on that.
Yes, I can comment about that, yes. So I think the first point I'd make is that how does it manifest itself? And one of the points that I've made very clearly is these non-disclosure agreements are a very clear manifestation of their approach, which is a purely commercial approach. So for residents, I'll give you an example. Both RMS and Metro have the same approach. You'll fight it out and negotiate with transport and come to an agreement, and you can't even tell your neighbours. And the reason for that is you're wanting to deny other people the opportunity to have that fact, deny them transparency, so you can negotiate hard when it comes to costs. That, in my mind, is appalling. This is public money for a public project. They should not have NDAs. There should be the free flow of information. And that, to me, is one of the manifestations of the cultural problems. We've seen some improvement in transport over time, but again, it's an example of, the black box approach. At the moment, we have a situation, I'll just give this very briefly, we have a situation where if you have damage to your property, you have to go to a multinational construction company and seek compensation from them. So the people that are alleged to have caused the damage are the ones that decide whether you get compensation. I mean, it's a remarkable conflict of interest. And so people often are stuck in a situation where they're begging to have their homes acquired because they can't get the damage resolved. There's now been an independent, so-called independent property impact assessment panel. No one knows who goes there. No one knows what the results are. No one knows how many appeals are positive and how many are negative. Completely impenetrable. And the only reason that's been developed, Mr. Graham, is because of the experience of WestConnex. There were reforms. Metro has never had that. Okay. So Metro has never seen the benefit of those processes.
Yeah. And Councillor Lockheed, do you want to briefly comment on that? Have you got any perspective you want to put?
Yeah, I would say I would agree with Mr. Parker's comments, particularly around things like the non-disclosure agreements. The only reason I was able to be as frank as I was in my submission about the very large gap that existed between the first offer that we received from the RMS at the time and our final settlement was because we weren't required to sign a non-disclosure agreement. And I don't like putting that out there. It's horrible. This is one of the taboos in society. We don't talk about money, but I feel it's really important for people to know that if you hang in that process, you can get a life-changing difference. And that should not be the case, but it clearly is under the current system. And I would add with the independent property assessment panel that Mr. Parker noted, I have known some residents who've gone through that, and I haven't had very positive feedback about the process. I must admit, it feels to those residents like the feedback I've had is that the people who are appointed to that panel know what they're talking about. They genuinely want to do good work and help residents, but it then gets stuck in the process with the government agencies.
Thank you. Mr. Parker, I want to ask about the view you're putting about substratum acquisition. I can understand the view you're putting that if it impacts on someone's value, there should be compensation. But there's also another principle which is essentially in New South Wales, any of the value below the earth is owned by the public. How do you avoid, given the view you put in, getting yourself into trouble about how that principle's applied, say in the west of the state, where someone might discover gold, discover lithium at the moment, that's owned by the public. The public gets a return if someone wants to exploit that. If you assert the principle, and I can see reasonably why your residents want to do that they might own the property to the core of the earth.
Yeah. I think the issue here is, let's first of all see what the government says. The government says, well, we have to require substratum because that's required in order to put the tunnel through there and we need to own it. And what the residents say and what the government says is there's no impact on you, so that's why we're not giving you any compensation. But what we know is that there are two key things. One, there is market value impact. Even, the layperson would say, if you have an 8-lane motorway, 6 metres in some cases below your property, that's noted on
So I accept where you're heading on that. I think that's a common sense principle.
Yeah.
How do you distinguish between that and the other, I think, valuable principle that the wealth under the earth is owned by all of the public?
Owned by the public.
In New South Wales.
That's an interesting question. I can make a further submission on that. I don't think in the 60-second answers we've got, I could do it justice. But I think the reason why I mentioned the issue of the notation on the title and the impact is there's a direct connection between substratum acquisition and value of the property. And that connection, I think, is different to a minerals connection because you're actually degrading the value of the property on the surface. And the other point that I think I'd make as well, which really riles people, is that actually this purpose is not really a public purpose, it's a private purpose because they're selling it. So the state is doing something that a private company could never do because they'd have to negotiate on a market value and, you know, buy people's homes and houses, just for it to be handed over and sold to a private company. So, you know, in a sense, the state is profiting from that acquisition, which is a role only the state can do. So there is a lot of concern about that as well in the community. I know that other residents have spoken about that to the committee.
And I might finally give you the chance to just put your view on the record, perhaps in more detail than you have in your submission, on the way that a betterment levy might work. You pointed to the ACT scheme. How might that apply to New South Wales?
Yeah, that's an interesting issue. I mean, one of the challenges that I know that you have to deal with is the Russell Review made a recommendation 16, about not just buying back at market value, but if there's an uplift, paying the person whose property has been acquired that uplift. Value uplift is a significant issue. Here in New South Wales, we are in a very unusual situation internationally that the landholder receives the full benefit of value uplift. So all it needs is a council or a state government to rezone or introduce an aerotropolis, and there's huge value uplift, and the state basically is incapable of gathering that public benefit. In the ACT, I know it's a different system there, but 75% of the value uplift goes to the state for libraries, for roads, for hospitals, for all those issues. So, and we know that some of the modelling demonstrated it's around $8.5 billion that is lost to New South Wales, and just finally, you'll know that in Victoria, the Victorian government introduced, you know, a betterment levy, you know, a value uplift or value sharing mechanism, which is generating significant income. And rent-seeking land bankers don't deserve, in my view, to have that huge increase in value. It should be shared by the public and used for the infrastructure that we all benefit from.
And in your view, how transferable are either those ACT or Victorian schemes to New Zealand?
Well, the Victorian scheme is instantly transferable. And if you look at other jurisdictions around the world, value capture is something which is just commonplace. We've only just started that process in New South Wales. The Parramatta Road Transformation Plan had a very small value capture mechanism. There are some, but obviously so much more needs to be done. And councils are carrying the weight of so much of this infrastructure, while developers and landholders are pocketing huge sums of money through no work of their own, just because they managed to lobby effectively to get a land rezone.
Thank you, Chair.
Thank you. Could I just pick up on a couple of the comments that you both made in your opening statements around the attitude of acquiring agencies? And I think, Mr. Parker, you referred also in one of your answers to this sort of purely commercial approach involved with acquisitions. And Councillor Lockheed, you referred to the need for deep cultural change. And I think that has come out really clearly from the evidence we've received in this inquiry so far. I don't have much hope in relying on the government to sort of change the culture within its own agencies. What could we do from a legislative perspective, do you think, to try and drive that cultural change?
Well, I think the reason I commented that having some sort of independent mediation service come in that had the power to compel agencies to genuinely negotiate is important, because certainly what my family found was that once we entered the court process, so the Land and Environment Court began that mediation process, we suddenly started seeing resistance to some of the claims that we put forward drop. And you can see that in the final amount that we received, the $1.85 million was nearly $350,000 more than the offer we'd had at 1.5. But that negotiation process didn't really start in earnest until we were a few weeks out from the Valuer General, I've forgotten the name of it, but when our property got gazetted, and we would have had to go to the Valuer General. And I know the committee has heard similar testimonies from others through this process. Now, the issue is at the moment is that there's nothing in the legislation that compels agencies to genuinely negotiate. And I think the reason that changes once you enter the court process is that a lot of the rights that landowners have to various elements of compensation are actually in case law. And so unless you are in a process where a judge will call you out if you are not awarding compensation that you are required to, there's nothing to compel the agencies as it stands to do that.
Yeah, look, it's an interesting question. I kind of approach it from a different angle. I do think that what Councillor Lockheed has raised is particularly important. You'll note in my submission that for a lot of people, a letter about a compulsory acquisition of your home is like a bolt of lightning. It is absolutely devastating for people. People don't understand the legal system, nor should they. They don't know who to turn to. The evidence isn't clear. Some people don't have English as a first language. It's a really terrifying situation that people find themselves in. And so one of the proposals that we've suggested, very similar to what Councillor Lockheed has, is there should be some kind of independent legal advice. And so that could be delivered through like legal aid or providing specific program funding to a network of community legal services, because all of the lawyers are out there letterboxing. You know, all of the class action kind of lawyers come to us. People don't really know what to do. It's very difficult. But even if the transport authorities had a very commercial approach to it and a culture of an adversarial culture, the problem is they can only get market value. That's why I'm a strong supporter of the Russell Review's recommendation about reinstatement. Because reinstatement is subtly different but critically different. So this issue of reinstatement would, I think, resolve a lot of these issues, because even if the departments were particularly culturally adversarial, reinstatement is a step above the existing arrangement, even with the compensation measures. I might just say one thing very briefly, though, that we're talking here about compulsory acquisition, and that's particularly important, but there's another type of acquisition, which is hardship acquisition, which I just want people to note. What we've seen in so many circumstances, especially around WestConnex, is that you're the last building left standing. And they'll put an 8-metre wall next to you, and you'll have a massive motorway next to you. Now, that home has had a huge impact on the value of that property, yet they're not being compulsorily acquired. Or you have someone that has significant damage to their home, and they can't get compensation. So they come to transport begging for an acquisition. And I've seen people literally begging for their house to be bought from them, even though their children have been brought up. The house is just, the impact is so significant. That type of acquisition needs to be reformed as well. It's so incredibly difficult to get a hardship acquisition. And in that such circumstance, with hardship acquisitions, you don't get the benefit of a moving allowance, funds for moving, for other costs. So what they sell their houses for is remarkably low. And the final point about that is WestConnex will say, or Transport, we're not going to acquire your property because there's no impact on it. But then when they do a hardship acquire it, they give it an incredibly low price because they say you're next door motorway. I mean, both of them can't be right. So I'd encourage you to look at hardship acquisition as well. Thank you.
Thank you. Do you think that there's a need for the legislation to deal with different types of property owners differently? And this is a question I've been asking a few witnesses to try and tease it out. But clearly, there's a big difference between a land banker and someone who is clearly speculating on the property, and that's why they have bought that property in the first place, versus somebody who has lived in their house for decades who is now being acquired. Do you think that the Act should try and deal with those two groups of people differently?
That's a tricky one to answer, because I hear what you're saying, absolutely. I also do know of people who were acquired through the WestConnex project where they weren't property moguls or developers by any measure. They just simply had a property that they had bought some time ago and were planning to use that property to retire in, to support their superannuation and so forth. And whatever you may think about that system, if that is somebody's main investment for retirement and suddenly it's taken away and they are not reimbursed with the compensation they need, that has major impacts on the rest of their life. So, and I think to some extent the legislation, as I understand it, does have some differences there. So, for example, you're not entitled to certain types of compensation if it's not you own an owner-occupier versus other types. That's just my view on it.
Yeah, I think obviously more care needs to be taken with the owner-occupier and the rental tenant, who will get evicted. That to me is very important. The issue that I raised earlier about some form of independent third-party legal advice where someone feels that they don't have to spend $5,000 to get advice about their rights would obviously be taken up more quickly than by a owner living in their home. I note the same public listed company in my electorate took transport to court on the issue of an acquisition. Some of these large companies obviously have got the money, the capacity to take on transport. So I think mostly they will just get their own independent advice. But there does need to be more compassion and care shown to a person who, quite frankly, it's their biggest investment, their home, and it makes a dramatic impact on their lives.
So just one last question, if I may. Especially you, Councillor Lockheed, you spoke about this kind of power imbalance, and I think it comes clearly through both of your submissions. What do you think, I guess, about the idea of some sort of facilitated grouping together of people who are having their homes acquired, where there is an ability for groups of like-situated people to negotiate in a transparent manner with the acquiring agency? Do you think something on those lines would be helpful?
I think the challenge there can be that even with properties that are next door to each other, there can be significant differences between how those properties have been improved, how many bedrooms they have, all of those basic things that make a big difference on the value. I do think it would be really definitely what the acquiring agencies did, or the RMS did in our particular case, was they really tried to pick residents off against each other. So I definitely think, even if it's not some sort of formalised negotiating together, an ability to get people together, to have them be able to speak openly to each other makes a huge difference. And I know certainly in my community there was a huge amount of misinformation going around about, well, what did that person get and what did they get and so forth. And this is at a time where I can completely understand it, because emotions are so heightened and people are in such a stressful situation. So I agree that giving people the freedom and the ability to speak to each other openly about how they're going with those negotiation processes would be a real help. And I have to agree with Mr. Parker, a lot of this would just go away if people got reinstatement value as their compensation, because the big problem at the moment is you have to fight for every element of your disbursements or the costs, and you have to really fight to get market value at the same level, and a lot of people are losing that fight.
Maybe reinstatement would lead to that cultural change.
Yeah. Absolutely, because the fear that you won't get enough to stay within your community or to buy an equivalent property wouldn't be there, and that's that fear that drives a lot of the issues we see with this process, I think.
Yeah, one of the challenges is that we can see, and in the 12 years that I've been a local member seeing all these acquisitions, is the objective is to atomise the resident, atomise all the people, individually negotiate, have confidentiality agreements, don't tell anyone what anyone else is doing, don't let anyone else learn from the experience of what anyone else has gone through, so every single person feels like they're on their own. And that means that you minimise the amount of people that appeal to the Valuer General, and you also minimise the amount of people that go to the Land and Environment Court. And so I think that any process that would improve transparency and bring people together is a good one and would actually yield positive results. Unfortunately, it's the opposite of what's being proposed. You'd think these people were negotiating, private share market deals. This is people's homes with taxpayer funds, and it should be public, it should be open, it should be transparent. And the fact that people are gagged from speaking to their neighbours, speaking to other people in their community about what they went through and what compensation they received is a travesty when it comes to open and accountable government.
Thank you. Mr. Bonacia.
Sure. Just picking up on Ms. Boyd's question to you, Councillor, about, I guess, some legislative change around, I guess, what is genuine attempt to negotiate. You brought up in your opening statement about being lowballed, and we've heard a lot of that through the inquiry. Would you support some strengthening of, I guess, that language around what is genuine, and maybe codifying what is in common law in terms of good faith negotiations, and having maybe some sort of trigger point or a remedy that landholders can say, well, you haven't negotiated in good faith, therefore I'm ceasing negotiations until you want to come back to the table and do so.
Look, I think that would be an excellent idea. It's clearly needed, because you've heard from agencies throughout this inquiry who've said that they are meeting all of the legislative requirements. They're acting under the terms of the Just Terms Act, yet we're not seeing that parlay into any sort of genuine negotiation in many cases with people whose properties are being acquired. I think the challenge with the timeline, where you've said that residents should be able to walk away, is part of that power imbalance we see between inquiring agencies and the people being acquired, is the fact that you don't set the timeline as the person being acquired. There is a deadline at which the government will gazette your property, and then you lose ownership of it. So this is the other reason why in many cases the acquiring agencies under the current system really have nothing to lose by letting that clock tick down. And obviously that's a huge detriment to the government and the public interest, because, as Mr Parker noted, the more we can reform this system for the better, the fewer people will go through the Valuer General process, the fewer people that will go through the Land and Environment Court process, and that's a huge saving to the public purse. And I have to say that when Mr Parker said that, it reminded me of when we were in our mediation conference, our conciliation conference. I think at one point in time we had 6 lawyers, 5 to 6 lawyers in a room arguing about cleaning costs. That is a ridiculous use of taxpayer money, and it could have been resolved so much easier, so much earlier.
I'll just go to one part of your submission, Mr Parker. You talked about how with the issue of WestConnex that it wasn't actually the property owner that was notified first, but the tenant. What was the department's response to obviously those concerns that you've received, that that was sort of receiving second, third hand, obviously very late?
Yeah.
Did they give you a response?
Well, they felt that it was a very expensive process to write to property owners that have to engage with councils to find the owners.
Legislation is pretty clear that they have to actually do that.
Yeah, well, we thought that was unsatisfactory, and I think when it comes to informing people about the in the zone of influence, the zone of influence, they should be writing to the actual owners of the property rather than just writing to the residents. That's something that does need to be improved and does need to change. We know that the owners eventually hear about it, but that delay is unsatisfactory. And while it's more expensive, and I understand, especially with the zone of influence, we're talking about over 4,000 properties on the just one arm of WestConnex. It does need to be done, and that needs to be carried out, efficiently. Can I just say just one brief thing, just following up from Councillor Lockheed on that issue of lawyers? It'd be an interesting question for the inquiry to ask exactly how much has Transport spent on lawyers fighting acquisition claims, and that means from day one when they make an offer. I think that would be very interesting to get a sense of what that quantum would be.
Yeah, sure. And just finally to you, Councillor, I know you spoke about your experience, and it's quite clear in the submission that if you hadn't fought this all the way, you wouldn't have got the figure that you did. But we've also heard from the Valuer General, who's actually put it on the record that the people that are doing these valuations weren't following legislation, weren't following regulations, weren't following policy. Do you think we need to maybe make a recommendation that the Valuer General actually goes back and looks at some of these offers that were made to people, that they accepted it, they accepted the low ball, they didn't fight it like you did, so we can get a sense of an extent of how badly people have been cheated through this process? I
would 100% agree that would be a great way forward. I did say in my submission that I believe that the acquisitions for WestConnex need to be investigated. Appreciate that would be a very big task, but I think at a minimum, going back to the people who, as you said, accepted an offer, particularly given the way that the government positions those and the government agencies position those acceptances, that because they're defined as being settled by agreement. Now, that's a very different definition of the word agreement to the one that I think most people hold. And so giving people who want to have their case revisited the opportunity to do so, and to have some rectification be made available for those people, I think would be a really important step forward for the government to reinstall faith in this system.
If I may just mention that as well, that is an incredibly important point, because you have to remember what happens in that meeting is you're sitting there with a gang of lawyers and they say, this is your offer, and then the resident says, well, I'm not sure. Well, if you appeal to the Valuer General, his value could be less. They say that in every situation, and if you don't agree with the Valuer General, then you've got to punt up tens of thousands of dollars, possibly $100,000 to go to the Land and Environment Court. People are basically bullied and demoralised into submission. And hearing that evidence, I think, was alarming for anybody who believes in, good public governance.
Can I just, sorry,
We're almost at you.
I'm happy to concede that I've only got about 20 seconds. So
No, I was only just on that point. When there's a negotiation and those that are seeking to acquire the land say, this is the offer, you can obviously go to the valuer general, however, that value may be lower. I understand you've phrased it in a way that it is a negative. The declaration of that fact is a negative. Is it not, though, the case that if that isn't highlighted, that the person having the land acquired would rightfully be able to say, but I was never told that that could be lower. This is the issue with a lot of and it's certainly come up throughout the day as well in other questioning, is that while it obviously creates anxiety, if you don't declare it, then there is, I guess, an argument to be made that you haven't fully declared what is potentially part of the future. Is it not just the case that people are just unhappy and really nothing that's going to happen in this process is going to resolve that unhappiness? And that's something, I can see that, but I just think that's something that needs to be accepted.
I take your point. I suspect it's in the delivery of how it's being put to you. There's many ways and tones of voice you can use to put that sentence to somebody. To an extent, you're right in terms of the unhappiness. If your home is being taken away from you, if your business is being taken away from you, it's never going to be a great process. The issue is at the moment is that, and I know you've heard this from many people before this inquiry, is that by the time you're having those valuer general conversations, it's not like you're really close in terms of where residents want to be and where the agencies want to be. There are hundreds of thousands of dollars sometimes between what people need to move on and what the RMSs, I keep saying RMS, but government agencies are putting on the table for you before you have to make that decision to go to the valuer general or not. And also for many people, certainly in my case, and I think there have been many people in this position, by the time you get to that end of the process, you've been in this for months or years. There's been a lot of time for the government agencies to increase their offers, to genuinely negotiate, to have some informal discussions with people that, with a genuine view to coming to an outcome that is mutually acceptable. And in the cases you've heard about again and again, that hasn't happened. And so I think yes, of course, government agencies have to be upfront about what can happen throughout the process, but why are we in this situation where getting that told that you may get less from the valuer general is a really upsetting situation for people?
Yeah, and I think that's really the nub of why we're here, is that at the end of the day, as much as we dislike the fact that it has to happen, progress means that there will be times when properties need to be compulsorily acquired. I think we all accept that. And I think it's fair to say that on both sides of the political divide, it's happened. And, the Balmain's Leagues Club is the perfect case in point. It was compulsorily acquired by the opposition when they were in government for a failed metro line. Now, that then has sat idle for a number of years, and obviously that's part of your area, the electorate you represent, so you well know that. But it's really about how we engage and how, I guess, that empathy comes through, because it seems to me that much of the complaints around this issue is around perhaps a lack of empathy and a lack of understanding and that the communication. So is that a fair assumption, I think, of how I'm looking at it as somebody who's never had it impact me, but certainly I can see the stories, and you've got that lived experience, obviously. Is it that no matter what is said to you, nothing was going to make it better, but the way that it's delivered perhaps can make it worse. Would that be?
Oh, yeah, absolutely. And look, we saw the lack of compassion in many different instances. Obviously, the big ticket item when it came to lack of compassion was the fact that people were having to beg for their legal entitlements. At the end of the day, you know, there comes a point where it is about the money, no matter what else is going on. And if you're not getting enough money out of the compensation, you cannot move on. And we also saw the lack of compassion in just smaller details, but some details that meant a lot to people. So, for example, I knew a woman in Homebush who had marked the growth of her twin children on a wall, you know, on a wooden paling, as we often do. She had to fight the government to be able to take that wooden paling away from the property after they moved out and keep it as a souvenir. It was worthless to the government, but the fact that you have to leave absolutely everything in the property in order to be able to get your compensation, you know, there was just a lot of things that happened that didn't need to happen and made the situation worse.
Can I just comment on that very briefly?
Sure.
I mean, you've heard those stories about people that have to clean their homes and get it inspected and say it's not clean enough, and then the house gets demolished.
Yeah.
Because, I mean, just ridiculous things like that.
Yeah.
But the empathy factor is also a function of the disrespect people feel when there's a $22 billion project and the government's lowballing them $150,000 on their house. And they're saying, you've got 2 barristers here, you've got 3 lawyers, how much is all this costing? And you've been fighting me for 6 months during this voluntary period about $100,000. And now you want me to go to the Valuer General and you're going to tell me it might get lower? We're talking about, it's a $20 billion project. Can't the government afford to be generous? And I think that is the crux of it. That's why reinstatement value, I think, is particularly important, because the anger and upset people feel initially, you know, is, oh, don't take my house. But everyone, at least in my community, said, well, you know, I understand it, but let me buy something in the area where my kids go to school.
Yeah.
Let me at least do that.
Yeah.
And at the moment, the system doesn't allow for that.
Mr. Parker, it's very interesting that you raised that point, and I understand that you do raise that point, and I, again, as somebody who's never had this happen to me, can understand that, you know, that's a common sense approach. That, you know, in a lot of ways, what doesn't happen, it seems to me, in these instances, is that common sense approach doesn't get applied. But we know 2 things. One is that for every person who feels the lack of empathy, feels aggrieved by the process and everything else, there are other people who will attempt to take advantage of the situation. And that is I guess, the difficulty of the government, whether it be us or the opposition, if they ever return to power, in that circumstance. Now, we have to ensure that that there's a process and that it's followed, and given the angst and the fact that we're having a hearing like this, that you know, we have to ensure that it's rigorous and it's dotting the I's and crossing the T's effectively. But the other thing we know is that if we are, I'll say, generous with some of the offers around land acquisitions and the like, yourself, the opposition, will say, where's the value for the taxpayer? So do you understand again that there is a issue for the government of the day, whether it be us or the opposition, in ensuring that we don't be too generous in these situations, because it just provides political fodder for you and the other opposition to derive that. So again, it puts us in a difficult spot. Can you
I can understand where you're coming from, and we're not talking about a camellia here, where the government overpaid tens of millions of dollars. All we're talking about is the difference between market value and reinstatement value. And we're talking about owner-occupiers, you know, just regular homeowners. You know, so my sense is that we can be nuanced. Our governments and our bureaucrats are clever enough to develop a process, and that's why I encourage you to look at I'm sure you have the Russell Review, I think it was recommendation 17, where Mr. Russell recommended that reinstatement value and recommended that it be closer to the Commonwealth legislation than to the state legislation. So I'd encourage the committee to look at that, but of course none of us want to be profligate when it comes to taxpayer money.
Yep.
Obviously, we want to make sure we have a very careful and considered approach. But I think the difference we're talking about here, as Mr. Russell identified, is significant and would eliminate all of these problems. And even if we go to the even if someone was overplayed marginally, if we made sure that people's lives weren't destroyed by this, I think it would be still fair. And the public, I believe, recognises that everyone deserves reinstatement.
May I just add to that? I know we are banging on a lot about reinstatement value, but I just want to emphasise that I know the committee is about to hear from a number of people who didn't get reinstatement value, and so therefore you're about to hear about the impact on their lives. My family, the fact that we did get reinstatement value, we've managed to stay within our community. We didn't have to uproot our child from her primary school. We were able to move on, and that's while it all leaves a scar, you never really get over it. It does make the difference between, as Mr. Parker said, not having your life destroyed by this.
Yeah. I don't mean to sound unsympathetic. In fact, if anything,
I
must say, as a backbench nat from Wagga, for what it's worth, I can genuinely see and hear the anguish that people have around this process, and I can understand it completely. It's just, I guess, I have that dual perspective of, I can see what you're positioning, but I can also see the counterpoint, and so that's why I'm just curious to see how you view that counterpoint when it's, I guess, communicated in a, I'll say, casual conversational way, because it is, I think, as you can rightly see, something that needs to be considered. And I guess the other thing too, is it your view that different governments handle it differently, or is it the experience that you've had, I guess, from a representational standpoint in both of your roles as elected members, that these issues are not just confined to this government, but certainly all governments, as in the previous government had a number of compulsorily acquired projects around, around your area again.
You're absolutely right.
So it's more of a why I say it's more of a department issue. It's very much within the department. It's within the bureaucracy of the state government, as opposed to the elected.
Yeah.
Is that how you?
That's
see
right.
that?
And I note that our time's coming to an end, but
Yeah.
I think what Premier Baird did was laudable in terms of engaging the Russell Review and looking at reforming the system. That was positive, and there was a lot of bipartisan support for that. And the Russell Review identified in that process that we need to then have a look after the changes that we've made, and I think this is the progression in the right direction. Governments of all different stripes make some good decisions and some bad decisions, but what's important for us now is to say, well, we've learnt the lessons of this last period. How can we look at the recommendations that we didn't follow and see how we can implement them, and look globally. Look what happened with Crossrail in the UK, and look at Victoria, what's been happening there, but also acknowledging different jurisdictions have different approaches, and we can do better and learn from other jurisdictions that do it well.
And if I can just add, I think the reinstatement value helps the government there as well in terms of concerns about whether or not people are being overpaid for properties, because you have genuine yardsticks for, what a property is selling for in a local area. And then if you're getting to the point of where all you're quibbling about is whether or not a moving cost is feasible or a cleaning cost is feasible, you're now down in the thousands of dollars as opposed to the hundreds of thousands of dollars.
It's that lack of common sense being applied to the situation, I think. Yeah. Thank you.
Thank you. Thank you very much for both of you for your very detailed, considered submissions and also your evidence today. It's been very helpful. Thank you, Mr. Fang. So that concludes this session.
Thank you very much.
Thank you.
Thank you.
I really
Thank
appreciate you all having this inquiry too.
Thank you. To our next group of witnesses. Thank you very much. There's quite a lot of you. So I will get started. What we'll do is we'll go around, and I'll start over here with you, Ms. Gates. If you could tell us your name position title if you're here in any representative capacity, and then either the oath or the affirmation, please.
My name is Rosemary Gates, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Mr. Grigg.
You. What? My name is Roman Gray, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth.
Thank you. Mrs. Gregg.
Sandra Gregg, I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing else but the truth.
Thank you. Mr. Hare.
Yes, good morning. My name is Peter Hare. I'm the convener and spokesperson of RAW, which is Roselle Against WestConnex. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Bartholomew.
Good morning. My name is John Bartholomew. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Capuano.
Good morning. I'm Richard Capuano. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Finally, Mr. Charlton.
G'day. My name's Colin Charlton. I solemnly, sincerely and truly declare and affirm that the evidence about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Fantastic. Thank you. Now, because there are a lot of you, I would encourage you to keep your opening statements to no more than a couple of minutes. But I will start with you, Ms. Gates.
Okay. I live in Leichhardt, and the comments I'm about to make are fairly typical of those who have been impacted by WestConnex in my area. It's been marked by poor process and lack of consultation from the beginning. And in terms of item B, the conduct of agencies acquiring land for the WestConnex project, I'd like to make the following points. Changes to route and tunnel depths. Following the completion of the EIS, the route was subject to change, and suddenly residents who believed themselves to be unaffected were impacted. They were denied the right to comment. Residents also discovered that the tunnels were shallower than the EIS represented. In parts they're 12 metres and some are even 6 and 8. In terms of the information sessions conducted by WestConnex, during the project stages, the residents were ostensibly consulted. Consultation implies taking into consideration another party's views or opinions. There has been no consultation. Apologies. Information sessions were superficial, comprising poster displays and route maps of decisions already taken. At these sessions, our legitimate concerns about shallow depths, noise disruption and subsequent house damage were brushed aside or simply accepted as inevitable. The other aspect is technical information. We are unable to communicate directly with project technicians or engineers regarding technical issues. The only telephone access is through the community engagement team, who are unable to answer questions and refer them to the tunnel teams. Responses are then relayed back and are inevitably inadequate. There's no means to clarify or engage in meaningful, informative dialogue, and of course there's never any paper trail. Dilapidation and causation is another issue. We live with the threat of property damage. Residents have to prove causation, as you probably know, and have been forced to pay ongoing costs for independent engineering, property and satellite imaging reports. We pay that ourselves. The free property inspections offered by WestConnex are woefully inadequate, merely amounting to photos, and any request to carry out checks on door window openings was flatly refused to make sure that they work properly, etc. I might add that any resident living outside the zone of influence of 50 metres has no hope of redress. On item D, how government agencies conduct direct negotiations with landowners in relation to compulsory acquisition process. The subdivision of land was done without landowners' knowledge or consent. We first discovered that the substratum of our property was to be compulsorily acquired via the interactive tunnel tool. Eventually, we received official notification from Transport for New South Wales confirming the acquisition. We applied, of course, to Transport for New South Wales and the Valuer General for compensation, but of course this is denied under Section 62 of the Just Terms legislation. Next, we discovered that Transport for New South Wales had subdivided our land into lots of their own creation without our knowledge or consent. Then came the killer blow, our title deeds. Next, we discovered indirectly via a neighbour that it was intended that title deeds of affected properties were to be amended to reflect the existence of tunnelling, later confirmed by the Valuer General. This will inevitably have a negative effect on the market value of our property, giving a prospective buyer the necessary leverage to reduce the sale price that a comparative house unaffected by tunnelling would not be subject to in the same area. Like many residents, our equity is our home. We have no other assets apart from superannuation and savings. Again, in all of this, no prior discussion, no consultation, residents have been treated with contempt. And I make the point that the amendment of title deeds would have been known from the beginning, but Transport for New South Wales chose to inform landowners only when the project was well on the way to completion. It feels like deception. And I want to comment on the human toll. The human toll of this 24/7 project can never be underestimated. The mental health of residents has been severely impacted both by the tunnelling itself and the treatment by the consortium and government agencies, all of which could be ameliorated by fair and just compensation. Oh, and there was the small matter of explosives. An experiment, controlled blasting. That was going to happen. Fortunately, residents sounded the alarm, and fortunately, it didn't happen. But it would have happened if we hadn't. In summary, the WestConnex project has demonstrated the inequity arising from public-private partnerships, whereby public money is used for the ultimate benefit of private companies. The only conclusion to be drawn is that the project is for the benefit of Transurban and their investors at the expense of residents. In short, the New South Wales Government has acquired our substratum with the aim of selling it off for the monetary benefit of private enterprise without any compensation to the landowner. It is in effect the privatisation of the substratum of our property. We believe this is an inequitable and unjust burden for landowners, and that the Land Acquisition Just Terms Compensation Act 1991 should be amended to allow landowners in such circumstances to be compensated.
Thank you. Mrs. or Mr. Gregg?
During the acquisition, we were upset that we weren't given full market value as we were told in the first meeting we would get. We got an offer way below that, the first offer, and the second offer they gave us was still below, and we were advised that if we didn't accept that, there were any legal fees after that would be paid by us, so we didn't have the money to go on with it. And as well as that, my wife's health was suffering, and mine a little, and so we had to accept that. And even after that, they refused to give us any money at all. We had to get a bridging loan to buy a house before we could move out, and as well as that, they cut us back 2 weeks, and we had to get out earlier, so we had to approach the owners of the property, and so we could move in there sooner. And also I couldn't understand why there was no parity between different properties and why it was all kept secret. And our market value was way above what we got. And I couldn't understand why others got more. And that's about all I have to say at the moment. Thank you.
Thank you. Mrs. Gregg, did you want to add anything?
Yes, I will. We had a beautiful 5-bedroom house in St. Peter's, 4-car garage and everything. We completely redid it up before we knew about all this. And anyway, when we went to the first meeting, I remember them saying to us, you'll get full market value. So we thought, oh, well, if we've got to go, we've got to go. And anyway, the RMS offered us 1.425, and which we considered very low, and we were upset that the RMS did lie to us about it. And then we got another valuation of 1.6, obtained by Slater and Gordon. And during that period, we heard that a smaller 3-bedroom house in Campbell Road, St Peters, had been acquired from the RMS for $2.4 million. And we had a beautiful big house. My husband was born there in the house in 1946, and we completely did it all up. And it was just devastating that we had, well, I always tell everyone we were kicked out. And we asked about the 1.6, and they said, that's it. If you want to get any more, you've got to go to whatever and try and get it. And it would have cost us a lot of money, which we didn't have. So we had to get a bridging loan to buy a house up at Woy Woy, because they didn't give us any money straight away. We had to wait quite a few weeks.
8 days.
Oh, 8 days, yeah. And we, like I said, and there was also another 3-bedroom property that they got 1.85, and we were low. Yeah, so that's what we've been upset, and I suffer now from anxiety bad. I'm under a doctor, I'm under medication, and the only way I can feel good is when I tell everyone, oh yeah, we're kicked out, you know, otherwise I get too depressed. And that's after what, 6.5 years. Yeah, so that's all I've got to say.
Thank you. Mr. Hare.
Yes, thank you. I'm just wondering if it's possible if I could distribute a copy of this newspaper that Raw has produced to each of the members of the committee. Would that be...
You can table that and
yes,
you just pass it on to
Thank
the
you so much.
committee team. Thank you.
I'll get on with my introductory statement. Raw thanks the committee for the opportunity to make a submission, and it's hoped that the findings of the committee will reflect the wishes of the landowners of this country who've had the ownership of their land negated by the use of the state's significant infrastructure legislation for the benefit of private companies, a use that is currently the subject of a court challenge. It's universally held that land is owned from the boundary of a plot to the centre of the earth, but not so in some Australian states. With the simple stroke of an SSI pen, landowners' rights are vanquished. It's particularly telling that even in a small Southeast Asian country such as Malaysia, the rights of individual landowners are respected. In this regard, we lag significantly behind what many would see as a third world country. Raw contends that the New South Wales government has failed its citizens in relation to items 1B1, 1B4, 1D, 1E, 1F, 1G and 1I in relation to the following. The construction of the controversial WestConnex project. The total cost will be around 45.6 billion, not the 16.8 billion quoted. The business case is commercial in confidence, so the true cost may never be known. More than 400 homes in Sydney's inner west were compulsorily acquired and destroyed. The substratum acquisition by the state and the then privatisation of the underground by selling the projects to private investors. Landowning citizens' rights were essentially ignored. The recognition of impacts were only superficially explored. The diminution of land value has been completely ignored due to the loss of market value of the property because of the tunnel or tunnels beneath it. The lack of payment of any, let alone adequate compensation for substratum acquisition by a private company under the guise of state significant infrastructure. The methods used to issue compulsory acquisition notices, often 2 security guards accompanying a person in a suit who issues the compulsory acquisition notice. The take it or leave it offer of payment of approximately 60% of the current market value of a property. The issuing of an EIS prior to the design of a project, which is a cart before the horse approach and an obvious denial of natural justice. The public consultation process that is designed to divide and conquer and prove to be simply a box-ticking exercise with no appreciable impact on the EIS design. Community information sessions staffed by marketing people who are unable to answer specific questions, the failure to hold public meetings, the unwillingness to even consider alternative solutions, the refusal of contractors to attend community organised public meetings unless resident spokespersons were denied a position at the table. The denial of genuine and well-informed members of residents groups, myself included, to attend the compulsory community contractor meetings, even though that's set up by the government, even though this remains a statutory requirement. So this begs the question, who really owns the underground? The Latin maxim, qui est solum eius est est qui ad caelum et ad inferus, for those of you who are not familiar with Latin, I'll translate it.
All of us.
It simply means, for whoever owns the soil, it is theirs, up to the heaven and down to hell. Again, who is actually entitled to subterranean access? There's been an increased global dependency towards the privatising of subterranean spaces in cities. This is despite public monies often being used for underground infrastructure development. Given their critical role in the livability and function of cities, there's a strong argument to be made that underground urban space should be for the public good, not to benefit a private entity. This is a key urban justice question, particularly given the aforementioned plethora of privatisation. Conclusion. Raw is in total agreement with Lowe and Iverson, 2016, who state that mechanisms that allow much greater public input into how underground urban spaces are shaped, imagined and used are most definitely required. Raw agrees that we need governance practices that are not subject to the logics of accumulation, that unevenly distribute access, primarily based on who can pay. Garrett, Mello, Zarita and Iverson 2020 state that by asking and engaging with these questions, urban scholarship can explore ways to move subterranean urban development away from a techno-scientific tunnelling decision-making process to one that engages with the social, cultural, political and economic implications of urban infrastructural projects. Finally, Raw wishes to acknowledge the significant contribution made to our parliamentary submission by the many campaigners against WestConnex, and especially by Dr. Maria Lourdes Mello Zarita, 2020, challenging Subterra Nullius, a critical underground urbanisation project, Australian geographer, and the Environment and Society Group at the University of New South Wales. Thank you.
Thank you. Mr. Bartholomew, are you also making a statement
too.
Okay, if you could try and keep it short so we have time for questions. Thank you.
Thank you for allowing me to speak at this hearing.
If you could bring the microphone slightly forward.
When I read the terms of reference for this inquiry, I realised that the systematic misuse of government and corporate power that has characterised the WestConnex scam for a decade must have caused the same high levels of anguish and distress to others suffering from similar projects right across Sydney. Around the world, as well as here in New South Wales, infrastructure mega projects have become notorious as vehicles for money laundering and other activities that attract major crime groups. Governments have a choice between building the infrastructure that is recommended by experts and genuinely serves the needs of the communities they govern, or setting up infrastructure projects as a means of siphoning billions of dollars from the sale of public assets through the accounts of major contracting firms to who knows where, behind an impenetrable screen of commercial incompetence and state-significant infrastructure legislation that hoodwinks the public and ties the hands of regulatory and oversight agencies. Too often in the last 20 years, the New South Wales government has chosen the latter course. The first priority of the incoming government in 2011 was rewriting the Environment Protection and Assessment Act so as to deprive the public of its right to challenge an infrastructure project in the Supreme Court on the basis of its lack of merit. Regulatory bodies also lost the right to withhold licences or certification for state-significant infrastructure that had failed to earn them. Infrastructure New South Wales was set up as a super department with powers over all the other departments, including the power to stop any investigation of misconduct or crime relating to the infrastructure projects it prioritised. When governments choose or are tricked into building projects that prioritise the interests of people who pay political donations over those of people who pay taxes, the character of those projects is inevitably affected. Naturally, the manner in which support is allocated and routes are chosen for transport projects will differ depending on whether the project is primarily for public or corporate benefit. I live in an area that has been decimated by the brutal land acquisition process for WestConnex. Householders, businesses and councils alike were kept in the dark about a 60-year-old road reserve being reactivated. During the process of buying a house in Brown Street, a lady who rang the RMS to ask if the road reserve was likely to be activated was told, "No, never." A month later she received the compulsory acquisition notice for her new home. Standover tactics were used to grind down local businesses and residents, intimidate them, deny them the rights they were entitled to under the Just Terms Compensation Act, and withhold deposits they needed to relocate. One homeowner was arrested for entering his own home to get clothing and personal effects for his wife, who was undergoing treatment for cancer in hospital. He was thrown in jail and only released a week later after a judge found his mistreatment to have been completely unjustified. At government level, the planning processes for WestConnex were a sham from the beginning. The Auditor General's 2014 report revealed that the assurance process was ignored initially and then corrupted by the chairman of the Sydney Motorway Project Steering Committee, also head of RMS. When that process found that WestConnex was beset by so many serious defects that it was necessary to abandon the project completely, the head of RMS wrote a formal letter to the Minister, deceitfully telling him that the problems had all been resolved and the project was ready to go ahead. Every transport expert who made any public statement, submission or report concerning the many critical defects of WestConnex was ignored or ridiculed. When Tim Williams, the man most responsible for solving the chronic traffic congestion in the City of London, gave his professional opinion on WestConnex, he was personally threatened by the Roads Minister. Now that the tunnels under my area are finished, every house, shop and block of flats has moderate to serious cracking. Even families with homes made too dangerous to enter by removal of support by tunnelling have been given the runaround by RMS or WestConnex contractors for years before repairs are done, if any are. Surely the amount of taxpayers' money spent on denying responsibility must be greater than the cost of repairs by now. Thank you.
Thank you. Mr. Capuano.
Thank you for the opportunity to provide evidence to this inquiry. I am one of many homeowners who are willfully and fraudulently cheated out of compensation by a cruel and heartless government, simply to save costs. I was treated unfairly, treated with contempt, and punished for appealing the unreasonable offers made by the RMS and the Valuer General. I was bullied by dodgy valuers and nasty lawyers who dragged me through a corrupted process, appeals process that cost $300,000, and in the end, I got nothing. I was threatened with bankruptcy if I appealed the corrupted decision handed down by the Land Environment Court judge, who dismissed evidence and delivered the outcome demanded by the government, their lawyers, and their nasty barrister. My health and well-being has suffered significantly, and I've been unable to purchase another home in the Sydney area, which is, I was born and raised. So I ask, where is the fairness? The government agencies boast having deep pockets. Homeowners just simply don't stand a chance. We've heard other heartbreaking stories, and it continues now. More homeowners, and there'll be more homeowners in the future that will suffer the same treatment. Where is the fairness? Where is the justice? It's obvious we have been wronged, and I'm in contact with many affected homeowners, and we all ask, what more do you need? What more evidence do you need to finally fix this broken process? Hold the government accountable and ensure we are paid back the compensation that has been stolen from us, simply stolen from us. After numerous inquiries, myself and many others just don't understand the lack of political will to address this blatant disregard for procedural fairness that's been denied to landowners. Despite ample evidence that clearly indicates it was the clear intention of the government to fraudulently cheat homeowners, evidence that points to criminal and corrupt conduct, that evidence has been ignored. And let's not forget that Baird and Perrottet kept the Russell Review secret and refused to implement the reinstatement recommendation simply to save costs. As Clayton Barr spoke in 2016, the inquiring authority was simply enacting the government dogma, that is to rob from the poor and give to the rich. And even today, as we sit here, we know the committee will do little to hold the government accountable or fix the process to ensure homeowners now facing acquisition will be treated fairly, or recommend that we will be paid back the compensation stolen from us. We know that. You've all let the government get away with it, and it's been betrayal after betrayal after betrayal, lie after lie after lie. Homeowners here given evidence, our submissions. I have many homeowners who refuse to give submissions because it dragged up all the bad memories and they got nowhere for the inquiry into WestConnex, which was another absolute whitewash. So despite the overwhelming amount of evidence, to date not one Member of Parliament, even this committee, has referred this for investigation or review, or even review our acquisitions, or reported to ICAC. Your silence is acceptance, and that makes you all complicit. I'd like to table, if I can please, Chair, some documents that relate to Section 192 of the Crimes Act, which is obtaining financial advantage or causing financial disadvantage, which the government has done to so many people. Section 192E of the Crimes Act, which is fraud, which is clearly what has happened. And Section 11 of the ICAC Act, that requires a New South Wales government minister to report any suspected corrupt conduct. We have seen it time and time again. We've seen instances during the WestConnex where there was blatant corruption, but nothing was reported. So essentially, what we are asking the committee to do is recommend reforms and legislative change in the areas of transparency, accountability, and the provision of a fair hearing for landowners. And finally, to hold the government accountable. We want you to fix this broken process. Remove the fear and anxiety associated with acquisitions and restore integrity and public confidence in the acquisition process. We want you to restore the independence of the Valuer General and the Land Environment Court, who are tainted. They have been corrupted. The Valuer General sat here. He couldn't even look into camera as he read a speech prepared for him by DPI. It's blatantly obvious. Or, as Matt Keane suggested, get rid of the Valuer General altogether and initiate a valuation commission. Now, he said that in 2012 in his inquiry. We also want to ensure homeowners who will be impacted in the future are treated fairly and with dignity. But most of all, we want you to ensure that we are paid back the compensation stolen from us. This is a valuation system that is in need of a paradigm shift, to quote Matt Keane, now Treasurer. But more importantly, it requires members of Parliament and members of this committee who will stand up for the fair and just treatment of homeowners. Thank you.
Thank you. And finally, Mr. Charlton.
I'd start by apologising to the staff. I was a bit reticent to even come here. A number of times I didn't reply to emails, etc. I did not want to relive what happened in 2016 with the acquisition of WestConnex from my home. I experienced all sorts of things. A lot of it's sort of been talked about. One was mopping the kitchen floor for a house that was going to be demolished. Yeah. Disposing of a few pot plants because somehow that was they would reduce the value I got for it. It was just petty, ridiculous. I got to talk about this, and I wasn't going to, but I'm going to mention it because Pauline Lockheed gave evidence. I was here when she gave it. I lived in number 2 Brown Street. She was number 4. We were next door neighbours. I received $1.4 million, which is a lot of money. A lot of people, rent. They're not even in that lucky situation. But she received $1.85 million. The land area was very similar. Yes. My house was solid brick. When it was demolished by RMS, her house, under the cladding, it was weatherboard. And it was, a pad, not even painted properly, weatherboard, whatever. It was obviously there was the property, whatever way you look at it, They were, even if you say those properties are basically the same, a $450,000 difference in the payout just doesn't make sense. And as other people had said, you couldn't even take that into consideration, what the other properties... I didn't know that. She got her compensation a lot later on. Part of that was that she took it to the end process, the valuer general, etc. I got to the stage where I just had to give in. I just said, look, I can't take this anymore. And I was suffering depression, I couldn't sleep, all the rest of it. I think I have got over that, and even just coming here today worries it's going to bring it back. One of the things that happened to me was the lawyers that I had were overseas. They weren't the lawyer I was communicating with. I tried to ring him and couldn't get him, and found it. Finally, he said, "Oh, you woke me up." It turned out he was in New York. You know, this was the sort of way, even the contempt of the lawyers, the way they did their job for you. I was in a crisis. I wanted to get this settled, and I just needed to contact the lawyer, and I didn't know he was overseas. WestConnect's RMS constantly broke their promises. They would say things like, "We will, pay you next week," a month later or something. They would, and the whole process was just wearing you down and making it so you gave up. I was in a bit of an interesting situation. I think even my fellow residents were surprised because I did fight WestConnects. In some ways, that was the only way really you could stop this happening. Because I was a landlord, at least at the time. My house was rented at the time. Therefore, I did not get any salarium, I think it's called, because that was ruled out. And then Mike Baird, the Premier, did a formula where people got some extra compensation, but I didn't get salarium, and it was based on salarium. So, say la vie. The whole way that it was done, WestConnects, is just got you down. Again, there was 10,000 whatever submissions at a number of stages, WestConnects. It was, in its sense, a fait accompli once it was approved in Haberfield. This octopus just keeps going. At the moment, now it's going south, now it's going into the North Shore. It's sort of like this has started, we can't stop it, it causes traffic jams, it creates congestion, we've got to move that further on across the harbour or down to Sutherland or whatever. This is how it works. WestConnects, when we opposed it, we said things like the whole project should not proceed. It was obvious, and even now, there's still traffic jams. I go through St Peters, I actually occasionally drive over where my house was. And there's all these traffic congestion is still there. Will it be relieved by the joining of the Rozelle and the St Peters link? I doubt it. It'll just magnify the problem. If it was, I would in some ways feel much better. If it was for something that was for the public good, but it wasn't. It was creating a situation that made things worse. A situation that's in many cities around the world, they have stopped building freeways. If not, then now some of them are bloody veggie gardens. That's basic. Oh, sorry, this is one other thing I want to say. Finally, I'd like to really emphasise that I heard this in the last witnesses and now. What happened with WestConnects? It was bought using public powers. The land I owned and all these people owned was using the public powers of acquisition that went to a private company. That, to me, is totally immoral, if not corrupt. It should just not happen. There should at least be a moratorium. It can't be sold for 10 years. There should at least be some sort of thing where the massive profits that Transurban makes of it, on the generous deals they got for the government, should be shared by the people who were totally destroyed by this. And the St Peters community, as John said, has been destroyed by this. Thank you.
Can I just add to what Colin says, please? The sale of WestConnects, that money should not only be used for whatever you guys want to use it for, but pay us back. Use that money to pay us back. Simply acknowledge what you've done, the heartache, what you've done to us, and just pay us back, seriously.
Thank you. To the extent that you were reading from prepared statements, it would be great if you could table those afterwards so that Hansard has a record. That would make it easier for us. And before I pass to the opposition, I do want to say... I only read... Oh.
But I've marked them.
Okay.
No,
I'll just wait for you to get your Statement's done? Okay. I just wanted to thank you all very much for coming and providing your heartfelt evidence based on your experiences. You're certainly not alone. We've heard from many, many residents and the themes of feeling that this has been done in an incredibly unfair way is, that permeates throughout everybody's evidence. And as a committee, we're certainly, the reason that we've set this up is so that we can look at how to do things differently in the future and potentially to investigate the way that things have happened in the past. Mr. Graham.
Thank you, Chair, and thanks all for your evidence. I think you've covered in a really important part of the picture with just the stories about how it's impacted on you all as residents as you're working through this. In particular, I think the case you put about secrecy and just how that really impacts on people is very strong. I find that pretty compelling. One of the questions as you were talking about it that I was wondering about was you clearly do know a bit about how other people are, what prices other people are being offered. How did that happen? How did you get that information? Was that just as the community was talking to each other as you went?
No, freedom of information at a later date.
Right. So at the time, so you found that out later, but at the time, that information
at the time we knew nothing.
Almost impossible to find. Yeah.
Only the first price we knew, that was it.
I can probably shed a little bit of light. As the convener of RAW, I'm in touch with something like about 850 families who principally reside on the Balmain Peninsula and the adjoining suburbs. And I've received literally hundreds of emails and phone calls from people who were incredibly distressed about the whole process and who confided in me that they had been forced, coerced, badgered, bashed into accepting something like 60% of the market value of their property. Sure. Now, that just simply means that they have to divorce themselves from the community that they live in. They simply were not able to relocate within their own geographic community, within their own circle of friends. The community hasn't really been mentioned, really. In terms of restitution, completely agree with that. Heard the last speakers in the last session. Absolutely. Restitution and what that means is clearly what is needed. But how do you put a price on community? How do you put a price on...
I'm going to interrupt you just because we've got a short amount of time.
Can I just quickly add, we found out about the $2.4 million acquisition from realestate.com.
Right.
So what they did, we went in as a group, they divided us. We approached our lawyers, Slade and Gordon, we approached the RMS, and they refused. They refused to even acknowledge or allow us to include that $2.4 million, which drove all our prices down. $800,000 difference. They had a significantly better house. $800,000.
All right, thanks for that. One of the, I think the point you've made along the way about information sessions and the fact that there's certainly not consultation is a really strong one as well. I just want to put that on the record. Have you seen any change over time? I'm just interested in whether this got better or was it just as bad all the way through?
I'm in touch with a lot of homeowners who are going through the process now. Speaking with people who have been through it and about to go through it. There is still that fear, but nothing's changed. It's gotten worse. They're still being cheated.
I would endorse that. I'm in contact with a group at the end of the peninsula, which is called the Western Harbour Tunnel Action Group, and essentially they are the next cab off the rank, effectively stage 4 of WestConnex, which has been renamed the Western Harbour Tunnel because that's apparently a more palatable description than stage 4 of WestConnex. Those people are also experiencing exactly the same concerns and issues.
But part of the big lie is that homeowners like Ray and Sandra here and Colin are deemed negotiated acquisitions. The big lie. At that 80% figure or whatever the government ban is around this website, negotiated acquisitions, they're sitting in front of you. They're bullied, they're cheated, threats of lengthy and expensive legal action. It cost me $300,000 in the end. The process was corrupted.
Can I just check, Ms Gates, were you trying to say something?
No, I just confirm and endorse what Peter here has said, that the consultation information consistently is bad all the way through.
Yeah.
It's
Total lack
too
of empathy.
Yeah. Okay. No, understood. That's been heard. Right. Well, look. Thanks again for your evidence. I'll hand back to the chair, but I hope it coming here hasn't, won't disturb you further. But it's certainly really valuable to hear direct from you about exactly what's happened.
Mr. Bonacio.
Thank you. As you know, this is our last hearing, so obviously we want to try and obviously come up with some recommendations that we can put to the government to try and make this process better. So I might just run through some of them and just see if I can get some general agreement as to whether you would support such recommendations. We heard from Councillor Lockheed that she supported the idea of strengthening legislation around good faith negotiations, because at the moment it's not really set in law as to what is a good faith negotiation. I think we've heard lots of evidence where people have felt cheated and lowballed. But would you support some strengthening the language around good faith negotiations, where you as a landholder can say, pull up stumps and say, no, you're not negotiating in good faith, I'm ceasing.
Not only does it need very, very explicit legislation, it also needs an ombudsman to oversee that legislation, because the power differential is so great and it's been so gleefully abused that you need somebody on the inside who speaks the government language to take that.
Integrity
And
agency.
also the difference between market value and the prices actually given. It's totally different.
Yeah, Matt, as I said, in a 2012 inquiry, Matt Keane suggested a valuation commission that was independent of the Valuer General. It's in his it's in his report. He was chair of that committee, and he states a few reforms which obviously he abandoned. He betrayed the people that he said he was going to stand up for, and then turned a blind eye while WestConnex happened. So there's a lot of reforms in there, and the structure of that valuation commission, you might be able to get some ideas, but something independent, something that's not corruptible by the government, like the Valuer General and the Land Environment Court. Those integrity agencies.
How are they corruptible by the
Order.
Can I just finish my second question, and then I'll allow Mr. Fang to pursue his questions. The last point we heard from the Valuer General, he gave evidence that that valuers weren't following legislation, regulation, or policy. Would you like to see a recommendation that an audit be done on past valuations to ascertain, I guess, the extent to which people may have been potentially cheated?
Absolutely. Utterly endorse.
The disparity in prices that people are paid. It's just ridiculous.
With the view of paying us back. That's important. Otherwise, there's no accountability. Otherwise, they just get away with it.
Thank you.
And I think the goal, as was articulated by Jamie Parker, should be restitution, which is, I think, that's the touchstone here.
That reinstate.
Yeah.
Thank you.
Reinstate. Yes.
That was a very quick.
Are you able to hold your questioning for another 3 minutes?
Sure.
Okay.
I'm very passionate. It's your birthday.
It is. Thank you.
Oh, I'll give you a few minutes of mine.
Okay. I just wanted to sort of look at those different options then. When we talk about reinstatement value, in the previous set of witnesses, it seemed that if we put in a reinstatement value concept instead of this market value concept, that perhaps many of these issues would go away. Do you think, though, that there would still be a need for, even if we had reinstatement, for there to be this sort of independent oversight, someone like a ombudsman or someone else?
Absolutely. Yes, definitely. Yes.
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 Right. Yes. Yeah.
Perhaps Infrastructure Australia, which was gutted in 2013, precisely because they did object to WestConnex on expert and rational grounds, needs to be beefed up a bit more and have some sort of punitive powers when a state goes ahead and decides they're going to brush aside a whole lot of really good infrastructure projects which have been needed for decades and instead go ahead with a scam directed primarily at money laundering, and which just looks like a tollway, because that way you get the benefit of state significant infrastructure secrecy and commercial in confidence secrecy, and all the other shields behind which you can hide that sort of thing. A lot of people have said that they wouldn't so much mind losing their homes if they knew they were losing it for something that was going to be of value to the community or to the economy in the case of businessmen. There's a lot of business, I haven't heard about any business people being represented here, but a lot of business people lost their premises, were bullied out of them, were shortchanged on compensation, were denied quick payments so they could get a deposit on another premises. And I don't know how many millions of dollars of private capital were burned up in that, but they deserve a bit of a representation too. Those people need to be protected as much as residents do.
Could I ask Mr. Charlton, we've heard in your opening statement, but also we've heard from some other impacted residents of, in other areas based on other projects, where they talked about, I guess, the impact on their personal circumstances being harder in circumstances where they couldn't understand why it was happening in the first place, I guess. So we've heard from residents in the West who were talking about it seemed nonsensical that particular projects were being put through their house and not somewhere else that seemed more obvious. To what extent did the impact on you personally come from WestConnex itself being a project that just didn't seem to make sense versus the way in which the acquisition was done?
Both, very much so. WestConnex, to me and to tens of thousands of residents who put in submissions, was just a stupid project. It didn't achieve anything, and I think it's being even proved now with the argument over tolls, the traffic that's still congested on the street where I was evicted. There's still a traffic jam outside the Town and Country Hotel in peak hour. There's still a massive traffic jam, and I remember I put in a submission to that and said there will be a traffic jam basically as soon as the WestConnex roads just stopped. A bit like some of the bicycle ways built in Sydney, by the way, too. And it's just, it just had no sense. It doesn't achieve what it's hoped to achieve. And as somebody else said, it's only really available to people that have got, the money to pay the tolls. And even then, I think there's going to be, there's changes are going to happen with tolls, with, billing for use mileage and all the rest of it. Anyhow, on my personal thing, it was the way they treat people. And part of it was connected to that was the glossy pamphlets. They put out, you get all these glossy pamphlets, that they send you, and 90% of it, more than that, is just saying how great WestConnex is. It's all about somehow, it's trying to say there's this useless project that we want you to accept it's a great project, therefore you should smile happily and let them take your property.
Thank you. Mr. Fang.
Thank you. Thank you very much for all coming in today. And I believe some of you were in the audience earlier when we had the last session, and I expressed how I have a great deal of empathy for the situation that you're all in. I can only but imagine the issues that you face and feel about it. But I just wanted to address one of the things that was said before, and it's about this continued theme that it's somehow corrupt. I fear that that is actually damaging the position that you hold, because I don't see how it's corruptible by the government. I just think that having sat within the government for the last 5 years, I've not known a single time where we're able to corrupt a process the way that is indicated by the testimony today. Can you somehow expand on that? Because
I would like to try and address that, if I may.
Thank you.
I think a perfect illustration of what we're talking about is documented in the Raw newspaper. The government elected to use CIMIC and ACOM, just to cite two organisations, to initiate this WestConnex project at a time when both of these companies, and the government were well aware of this, were under investigation for corruption on many levels in a number of overseas countries. That does not look good. It is a reasonable conclusion to draw from that the government is accommodating corruption. That's not necessarily proof positive that the government is corrupt, but it certainly indicates to me and to most other sane-thinking individuals that clearly if the government is prepared to offer contracts to contractors who are under investigation in overseas countries and give them contracts, something is rotten in Denmark.
Well, no, I'm sorry, that does not fly. I don't see how you're drawing a conclusion that the government has corrupted this process by that.
Can I jump in there?
You're alone in that.
Can I just jump in there?
I don't think I am.
Can I just
Please.
jump in there? You said you showed empathy towards what had happened to us. What are your thoughts on paying us back, for example? What are your thoughts on actually using some of that money that the government's obtained from Transurban, your donors, to pay us back? What are your thoughts on that? If you show empathy, if you show understanding.
What I will say
No,
about...
that's
No, sorry.
Don't give me politicians that answer.
Okay,
directly.
order.
We're asking questions.
Don't preempt him, please.
Well, look, I'll give you my view, and again, Mr. Russ, right, we're here to inquire, not to answer, but I'm happy to provide you my thoughts.
Please.
Is that I don't know enough about your situation to dive down.
Have you read my submission?
No, sorry.
Have you read my submission?
You've got to calm down, all right? This is not, and this is my point.
Okay,
is it's
order.
not helping your situation when these wild conspiracy theories are being presented as facts, because
Let me spell it out for you.
I'm sorry, I haven't
went to
finished.
the
You're
Land
talking over the
Environment
top of me
Court
now.
where the Valuer General put $950,000 on the table. The RMS came back with 900. I appealed that. I subsequently was bullied by dodgy valuers, Lunny and Watts, throughout this process, who demanded unnecessary report after unnecessary report to increase the cost to wear me out. The judge at the end turned around and said, based on evidence provided by the RMS, that my acquisition should be 1.3 million as a baseline. The RMS wanted that evidence dismissed, even though it was their own. They demanded and demanded and demanded, and we're talking about their barrister and Clayton Wood's lawyers demanded that the judge dismiss the evidence. He said, no, the benchmark's 1.3. 6 months later, the judge comes back with 1 million, which is what the RMS had demanded. Please don't tell me that the process hasn't been corrupted.
So is it your testimony now that the judiciary is a party to this as well?
Yes.
Can I just pop in there?
Please, Mr. Bartholomew.
The corruption was a big issue in the 2011 election. Labor fully deserved to lose that because of EDOB. And the government that replaced it had a mandate not to be as corrupt. So it's disappointing that the legislative priority in, I think, the second sitting week of the new parliament was to rewrite the Environment Planning Assessment Act. They promised to get rid of 3A, they got rid of 3A, 4A, 5A, 6A, 7A, the whole lot.
I get rid of all of
it was gone. And then remove the right, this is the crucial bit, remove the right of the public to challenge an infrastructure project that was devoid of merit on the basis that it was devoid of merit. That was the beginning of that government going down a very dark road. And then to set up an infrastructure New South Wales as an all-powerful body, the most powerful government department ever, that can walk into other departments and say, stop doing what you're doing. Oh, police, you're doing a murder investigation? Stop doing that, my cousin's involved. That's the sort of power it has.
I don't think...
It's unchallengeable power.
I don't think you are assisting your case by presenting these conspiracy theories.
Okay.
They are not conspiracy theories.
Well, I think if you're
It is
thinking that the
actually
government
what
and the
happened.
judiciary are somehow in cahoots, that
Order, Mr. Fang. Your questioning time is up. Thank you. Unfortunately, that is all that we have time for today. I would like to repeat my genuine gratitude to you all for coming and explaining to us the impact that these acquisitions have. It's really very helpful in terms of the evidence for the committee. Thank you. To the extent there are any supplementary questions, we will provide them to you, and answers will be returnable within 14 days, but the committee secretariat will be in touch. Thank you very much. That concludes our hearing.